and they want IEBC to correct that situation, and so that it can be reflected not only in this election that was just concluded, but also subsequent elections that will be held in the country. That generally will not in any way have a far-reaching implication on the presidential poll outcome, because according to the results that were announced on the 9th of this month by IEBC, Uhuru Kenyatta got 50.07% of the total votes that were counted, and these included the rejected votes, while Raila Odinga got around 43%. So even if the court was to rule that the rejected votes should not be included, all that will do is that it will increase marginally the percentages that Uhuru Kenyatta got, Raila Odinga got, as well as the other presidential candidates got, but that will not in any way take away the tally that was received by Uhuru Kenyatta below the 50% plus one threshold. So that is a petition whose outcome will not directly affect the poll outcome. However, the two petitions that will definitely have far-reaching implications depending on the verdict that will be arrived at by the Supreme Court judges are petition number 4 rather, and petition 5. Petition number 4 has been filed by a group of civil society organizations under the umbrella of the African Center for Governance, AFRICOG. The petitioners include Gladwell Otieno, Maina Kiai, John Githongo, to mention but a few. And all they are contesting is the electoral process that was used by the IEBC to conduct the March 4th general election, and particularly the presidential poll. They are insisting that the process that was adopted by IEBC had a lot of irregularities, and so that in essence affected the credibility and the integrity of the outcome. And they want the Supreme Court to rule that the process was not free, fair, and transparent. And all they're asking the Supreme Court is to rule that the outcome that was declared on March 9th is a nullity, and that a fresh election be held. Those are their prayers, basically. And that team is represented in court by Harun Dubi and Kathy Kilonzo. Petition number 5 has been filed by Prime Minister Raila Odinga and the Coalition for Reforms and Democracy Code. And just like the petition number 4, the prayers that have been sought in prayers number 4, basically they're asking that the results be set aside and that a fresh election be held. And the judges are already here, and so we will be joining the proceedings proper to hear what they have to say, but also expect some key rulings this afternoon and quite some legal face-off, so to say, as we witnessed early in the morning. Enjoy your evening, your viewing. Let's see what is happening inside the Supreme Court.
Welcome all.
The ruling on the application for amicus curiae will be read by Mr. Justice Ojwang.
Two applications were made before this court earlier in the day, both seeking admission to the status of amicus curiae. The first was by the Attorney General, while the second was by the Law Society of Kenya. The learned Attorney General submitted that the importance of presidential election based on the terms of the Constitution of Kenya 2010 justified the participation of his office as protector of the public interest in the capacity of amicus curiae. The Attorney General submitted that his office had no partisan interest in the matter and would in any case limit itself to such role as the court may approve. He urged that the Attorney General, if admitted as amicus, would do no more than highlight legal questions and in this way provide guidance to the court. Most of the several counsel in the petitions, Mr. Regeru, Mr. Abdullahi, Mr. Ngatia, Mr. Rebelo, Mr. Kigen, supported the Attorney General's application. However, learned counsel for the petitioners, Ms. Oraro and Ms. Kilonzo, opposed the application. While not doubting that the Attorney General would remain non-partisan as amicus, Ms. Kilonzo submitted that as the case was essentially evidentiary and not concerned with the interpretation of the Constitution, there was no special contribution which the Attorney General could make in the capacity sought. Council urged that the government needed not participate in the petition proceeding as amicus, since its role was like that of a respondent via the agency of the IEBC. Learned Counsel Mr. Oraro submitted that if the Attorney General was seeking admission to amicus status by virtue of Article 166 of the Constitution, then the application is inappropriate, since the proceedings are of a sui generis kind and are not civil proceedings. Council urged further that by current statute law, the Attorney General has an advisory role in the transfer of power from one state officer to another, and it is precisely this function which is contested in the petitions. After considering the several lines of submission by Council, we have taken note of certain governing scenarios which lead us to a final decision. Firstly, the state law office, the chief officer of which is the Attorney General, is the custodian of the legal instruments of the executive branch and the recognized advisor of the state in matters of public interest. Secondly, and interlinked with the foregoing point, the said office is the main player in the performance of the executive's role vis-à-vis the operationalization of the Constitution. Thirdly, the Constitution expressly provides that in certain instances, the Attorney General may obtain the court's permission to appear as amicus. Fourthly, the court, which is the custodian of rules of validity, propriety, and fair play under the Constitution and the law, remains in charge in regulating such precise role as the Attorney General may play if admitted as amicus curiae. These considerations have led this court to the conclusion that it would be improper to exclude the Attorney General from the role of amicus in these proceedings, and that admitting the Attorney General to such a role will not present a condition prejudicial to either the scope of the court's authority or the best interests of the parties to the several petitions. We find the position of the Law Society of Kenya to be entirely different. The submissions of Learned Counsel, Ebisha, in favor of admitting LSK to the status of amicus were by no means the most powerful. But our position has been conditioned more by the common direction and focus of the submissions made by Learned Counsel. The effect of Mr. Shah's submission is that since by Section 4 of the Law Society of Kenya Act, LSK is mandated to assist the government in matters relating to lawmaking, this is a typical case in which LSK deserves to be admitted to the status of amicus curiae. But the argument to the contrary is more powerful. Learned Counsel, Mr. Regeru, submitted that an affidavit in aid of one of the petitions sworn by the vice chairperson of the LSK left little doubt that LSK had taken a partisan position. And this same point has featured in the submissions by other counsel as well. LSK's application is opposed by Learned Counsel, Ms. Kilonzo, who perceives the applicant's role as partisan, Mr. Oraro for the same reason, Mr. Kamau Karori for the same reason, Mr. Rebelo for the same reason, Mr. Ngatia for the same reason, Mr. Keegan for the same reason. The court's position is now expressed in the following orders. A, the Attorney General is admitted to the status of amicus curiae in the petitions before the court. B, the application by the Law Society of Kenya for admission to the status of amicus curiae is disallowed. C, orders are made accordingly.
My lords, I wish to thank you.
The ruling on consolidation will be read by Justice Ibrahim.
Thank you. This is the ruling on consolidation of the petitions. We have considered the question of the possible consolidation of the three petitions, namely petitions 3, 4, and 5 of 2013. We have carefully considered the submissions by counsel regarding this issue. All these petitions are in respect of the same respondents with regard to one matter, the validity of the presidential election of the 4th of March 2013. As we have indicated, it is that time is of the essence in the disposal of these petitions, which relate to matters that touch on great public interest and on the Constitution of Kenya, which is the supreme law of the land. We agree with Council that petition number 3 of 2013 raises distinct and separate questions to be determined and is a stand-alone petition. However, we note the need for expeditious disposal, the time constraints, pressure on the court, and many complex matters to be determined. We are of the view that the 3 petitions should be consolidated as one petition. This means that petition number 3 of 2013 will be heard within the consolidated petition and the questions therein determined without prejudice to the parties. We hereby, therefore, order the consolidation of the 3 petitions. The file for petition number 5 shall be deemed to be the pilot file in which all proceedings shall be recorded and the final decision made therein. Accordingly, petition number 5 of 2013 shall be referred to hereafter as the first petitioner. The petitioners in petition number 4 of 2013 shall be jointly referred to as the second petitioner. The petitioners in petition number 3 of 2013 shall be jointly referred to as the third petitioner. The respondents shall remain as set out in petition number 5. Orders accordingly.
After getting the documents last week, we've gone through these documents as a court, and Judge Wanjala is going to give that ruling. It's some ruling you're making. Suo moto, is it in Latin? Okay, suo moto.
Having been seized of the 3 petitions challenging the presidential election of 2013, and having carefully studied the pleadings therein, the court hereby makes the following orders. 1, there shall be a scrutiny of all Form 34s which were used by the Independent Electoral and Boundaries Commission in tallying the presidential vote from each of the 33,400 polling stations in the country, including the Forms 34, which were used by the IEBC in tallying what is now commonly referred to as the diaspora vote. Number 2, the scrutiny shall aim at establishing the number of registered voters, the number of valid votes cast, and the number of rejected votes as indicated on each form. 3, there shall be a scrutiny of all Forms 36, which were used by the IEBC in aggregating the tallies of the presidential vote from all the Form 34s. 4, the scrutiny will aim at establishing the accuracy or otherwise of the total tallies of the presidential vote as indicated on the Forms 34. The scrutiny shall also aim at comparing the number of registered voters indicated in Form 34 and the number of the registered voters on the principal register. What constitutes the principal register shall be addressed in a couple of minutes for purposes of expediency. 6, there shall be a retelling of the presidential votes in the following 22 polling stations using the Forms 34 and Forms 36. I can quickly read the 22 polling stations. One, Lokosowian Primary School, Lomerimeri, Lontolio Primary School, Nairobi, not Nairobi, Nairobi Primary School, Mumone Primary School, Ntambiro Primary School, Kabutio Primary School, Mailitatu Tea Buying Center, Mtuuma Primary School, Mugumone Primary School, Kingatua Primary School, Pililai Trading Center, Sango Primary School, St. Andrews Primary School, Kabitoi Dairy, Boron Primary School, Don Bosco Primary School, Magenji Primary School, Chepkolon Primary School, Kapkurongo Primary School, NCC Social Hall, Koitabut Primary School, and Kamobon Orthodox. Those are the polling stations, but the constituencies from which the polling stations, in which the polling stations were situated, are also annexed to the list, which shall be given out. The retally, the principal register, that's number 8, shall be used in this exercise is the external hard drive presented by the IEBC in their annexure AIH.9 in the replying affidavit of one Ahmed Isaac Hassan. Number 9, this exercise there is number 7, which I have been graciously informed by my brother judge that I had missed. The retally shall aim at establishing whether the number of votes cast in each of these 22 polling stations exceeds the number of registered voters as indicated in the principal register. 9, this exercise shall be carried out on the 26th of March 2013 from 8 a.m. at a place to be designated by the registrar of the Supreme Court, and it shall be notified to all the parties by the registrar. The results of this exercise shall be filed in the Supreme Court registry by latest 4 p.m. on Wednesday, the 27th of March, 2013. Number 11, the petitioners shall jointly appoint 10 agents to act as observers during the scrutiny exercise as per orders 1 to 6 above. 12, the respondents shall jointly appoint 10 agents to act as observers during the scrutiny exercise as per orders 1 to 6 above. And 13, an oath of secrecy and confidentiality shall be administered to each and every one of these designated agents referred to in orders 10 and 11 above for the purpose of carrying out this exercise. The oath shall be administered by the registrar of the court on the 26th March 2013 at 7:30 a.m. The venue of the oath shall be communicated by the registrar. It is so ordered.
We are, although we've talked about the the principal register. But we want the IBC, Mr. Nyamondi, to basically address us on that issue, because what we are saying, what you gave us is a hard drive and what else? Yes.
And there is the register.
Yes.
Of voters whose biometric information was not captured.
Okay. So what you gave us, does it include the biometric, non-biometric? What does it? What?
It only includes those voters whose biometric details have been captured. It does not include the non-biometric details.
What you gave us?
Yes.
So where do we get the non-biometric data from?
We can supply that
When?
as soon as it's up.
Okay.
I think it's important for you to supply the court with all the documents you consider to be the principal register. So not just the CD-ROM. You need to give us the biometric, the non-biometric, and any other document that constitutes what you're calling the principal register. And also supply to all parties.
Ms. Kilonzo, your application will be coming later, and you will argue it.
Okay.
We wanted to give that ruling, which is a court ruling on this issue as we understand it.
Okay.
But now I'm going actually now to deal with the application. Is Mr. Alucheri here?
Yes, most obliged.
Okay, Mr. Alucheri. You wanted to join application to be joined in petition number 5, is it?
I applied to be enjoined to petition number 4, the one where Ms. Kathy Kilonzo is the advocate.
Number 4.
Yes.
And I understand that your applications have been rejected. You had applied to petition, it was rejected, right? Can somebody give him, Judge Ibrahim, give Mr. Alucheri the history of his matter?
I can explain the past proceedings in which Mr. Alucheri has been involved in. The first one is so that, because we got mixed up in the morning, so we told you to go tomorrow to the registry, but actually one application is pending here. The first application we dealt with was for Mr. Alucheri filed a pre-poll petition challenging the presidential election. It was dismissed, and we reserved our reasons to be given on 27th of March. However, because of time constraints and this petition, we are going to give you notice tomorrow as to when we'll give the reasons. Then Mr. Alucheri came back and asked to be given leave to be admitted, to be allowed to file a former pauperis, or rather, to file a petition as a pauper through former pauperis proceedings. It was disallowed. But now he's come back today and he's filed an application to be given leave to join as a co-petitioner in petition number 4. So the court would like to know whether you have served on all parties concerned, and whether you have consulted even the owner of the petition, the petitioners in 4, and whether they have given you leave even before the court considers that, and for the application to be heard today in a very brief proceedings.
Thank you very much, Your Honor. About a week ago, I think on the Monday, immediately after the declaration of the president-elect, I came to court and I presented my papers filing the application. The court formally received it on the following day, which is Tuesday the 19th, I believe, and I've basically been waiting for directions from the court since then. Immediately thereafter, I did file and inform the petitioners through the advocate, Kilonzo and Company advocates, of my application, and I've also served all the 20 potential respondents in my particular application. I've even filed an affidavit of service, which I believe was filed on Thursday in court, so everybody has been served. The only party that hadn't been served was in petition number 3. I believe the advocates is advocates, But today I did have a chat with Counsel Njoroge Regeru, and I've sent them by email. I've served everybody. So right now, as it stands, everybody who's involved in the petitions has been served. And it's only Njoroge Regeru and Issa who was served today, but everybody else was served as of Thursday last week. It was all complete.
Okay, in your words, what is the core of your petition? The application. What is it
the
that you
application,
want?
as opposed to, essentially, sorry, if I may ask for guidance, are you asking me why I want to be co-enjoined as a co-petitioner?
Okay.
I mean, basically...
That's what you want?
Sorry?
You want to be co-joined?
Yeah, I want to be co-joined as a co-petitioner.
Okay. Why?
The reason for that is I raise issues, constitutional, weighty constitutional, other legal issues, and even evidential issues that have not been raised by the other petitions filed in court. Petition 3 is very simple, dealing with rejected ballot papers. Petitions 4 and 5 are pretty similar, touching on tallying issues. 5 is a bit more extensive, even deals with issues of the voter register beginning even prior to the election. The issues that I raised deal with the qualifications of the candidates, whether they were qualified to take part in the elections in the first place, under Article 137, and also Article 77.2, again, a qualification issue, which is a Chapter 6 matter. These are issues that no petitioner in the 3 petitions filed in court has raised. In the interests of justice and in the public interest, any matter that affects the legality, that affects our Constitution, should be heard. And considering Article 48 talks about the state shall ensure access to justice for all persons, that is why even if I was blocked in one route, I went to the law, looked for another route to ensure that these weighty constitutional issues are presented before you, honorable judges, that you may consider them together with everything else. There is no point us saying we are following a constitution, yet we ignore some very weighty, pertinent matters that also should be considered in the collectivity of everything else that is being considered. My petition is very brief on evidence and facts, because evidence is very simple. Were the state officers qualified or not? You simply look at their status. This was their status when they presented the nomination papers. Qualified, yes or no? It's very simple. Facts, basically, in my petition, 3 paragraphs of facts only. The rest is just the legal issues, whether or not they should be, they should have been allowed to take part in the presidential elections, and if they shouldn't have been allowed to take part in the presidential elections, whether it is in order for the election of the president-elect to be invalidated. And I don't just talk about the election of the president-elect, because the issues that are raised concerning the president-elect also concern 6 of the presidential and deputy presidential candidates, 4 presidential and 2 deputy presidential. And therefore, in the interest of impartiality, lack of favoritism, if the issue touches on one candidate, it should also touch on all the other candidates. So in essence, Article 137 and Article 77.2 that have not been raised by anybody, those are the reasons why I've come before this court, that the court may consider these weighty constitutional issues and come up with a judgment on the matter. In essence, that is why I stand before this court.
Thank you very much, sir. Mr. Regeru. Yes, sir. Sorry.
Thank you, Honorable Chief Justice. The first point is that we have not seen this application at all. We have not been served. It is true that the applicant did approach me soon after the court rose, and he requested my email address, which I gave him. But between then and now, I simply haven't seen that application. But going purely by what the applicant says, I can have 1 or 2 comments. Number 1, he seems to zero in specifically on petition number 4. Now, we are not parties there. I know they've been consolidated, but we are not in that petition. Secondly, there must be a reason why he zeroes in on petition number 4, presumably because he identifies some close nexus between the issues raised in that petition and what he wants to articulate before the court. But then he very quickly contradicts himself by saying that he wants to introduce brand new issues that have not been raised in any other petition. So by his own admission, he seeks to advance before your lordships a brand new petition, if you like, on brand new issues not anywhere canvassed in any of these other petitions. And it seems, therefore, that logically, rationally, he's out of time. On that ground alone, then, there may be little benefit in admitting him to petition number 4 Therefore, in the consolidated body of petitions, if that is going to have the effect of introducing a brand new cause of action in the petition that has not been articulated anywhere else, he is hopelessly out of time, and I think in the interest of time, he needs to be disallowed, and we carry on with what is on record.
Thank you, Mr. Regeru. Ms. Kilonzo.
My lords and my lady, I do confirm that we were served via
By the way,
email.
I wanted to tell you that
yes.
you know, you don't have to wear that gown, and yeah, you can just wear a suit because you're going to start sweating in here. It's very hot.
Thank you, my
But
lords.
it's up to you, right?
I'll be
just in
guided.
case you didn't know, in the Supreme Court, gowns, wigs, and whatever are not, just smart suits.
I'll be guided
Yeah.
by you, my lord. Thank you. My lords and my lady, we were served with this application via email, and after taking instructions from the first and second petitioners, we advised him that we would be opposing his application to be joined to petition number 4, and we also served him electronically with a copy of a replying affidavit of a first petitioner, Gladwell Wadhoni Otieno. My lords, it is my humble submission that the Constitution and the Supreme Court presidential petition rules are very clear on how a party who is aggrieved with the conduct of presidential elections should approach this court. My lords, if the applicant had any grievances, he should have filed a petition within the 7 days required under the Constitution and followed the elaborate rules and procedures of this court. My lord, the issues the applicant seeks to raise and to join in our petition have no nexus to the clear grounds and evidence that the petitioners will be presenting in this court. What they will only serve to do is to cloud the issues and to muddle the evidence that the petitioners have brought before this court. My lord, it is my humble submission that the applicant and the petitioners have no nexus whatsoever, and it will be prejudicial to the petitioners for the applicant to be joined to their petition, because as the petition and the evidence will show, they have been involved in the electoral process, not after the results were declared, but long before, in conjunction with civil societies and in conjunction with other arms of the government. I therefore strenuously oppose that application.
Thank you. Mr. Oraro?
I really have nothing useful to add to what Ms. Kilonzo said.
Okay. Thank you, Mr. Oraro. Mr. Rebello?
Likewise, Your Honors, I associate myself with what has been said by counsel.
Mr. Abdullahi?
My Lord, we will oppose this application. I don't think it will add any value at all. I mean, we have 30 lawyers from distinguished background. What we cannot elucidate, I don't think a layman here will elucidate. I don't think it will add any value to this matter.
Mr. Abdullahi, this format I've been told, this is a very, very brilliant layman.
There are many, many brilliant lawyers. But the point I'm making is, my Lord, I think in all fairness, even the issue he's raising of Article 77 has no relevance in this matter.
Yes.
An election petition, there are only 4 constitutional provisions, 140, 138, 137, 136. Mm-hmm. So, but if he wants us to raise some issues, I think one of the lawyers surely can raise for him.
Mr. Zagatia?
For the record, my Lord, nothing useful to add to that which has emanated from my learned friends. Thank you.
Okay. Lastly, Mr. Keegan.
Nothing useful, my Lord, to add. I have nothing useful to add, my Lord.
Okay.
May I request you, my lords, now that I am a friend of your court, to include me among those people whose views you may seek, and assuming, my Lord Chief Justice, that you have given me. I was just going to say, Chief Justice, nothing useful to add.
A ruling on your matter tomorrow. I'll give you 2 minutes, yes.
Thank you very much. With respect to comments by Council Regeru, that the issue is out of time, I was here on the Monday immediately after the declaration of the President-elect and made my application, as Your Honor, Justice Ibrahim has mentioned, on an informal papyrus basis, and I attached my petition. If that application had been accepted, probably mine would have been the first petition that would have been admitted over here. So it is not a question of dilatory tactics on my part, no. I have made every effort to do everything by the law. The only challenge was that I didn't have the cash on hand at the time the petition were being filed, and that is why I was applying on an informal papyrus basis. With respect to comments, but that also answers the issue raised by Ms. Kilonzo concerning filing within 7 days. That was done on the basis that I've just mentioned. There is the issue of clouding issues in Petition 4. I think that has been overtaken by events since you've already ruled on the consolidation of the cases, and even with respect to Petition number 3, which is going to be considered in isolation, the principle applied to Petition 3 can also be applied to the issues that are raised over here. On the issue of Council Abdullahi, no value added, I think it needs to be reminded that I'm not applying as a friend of the court. I'm applying to be enjoined as a co-petitioner. I have issues concerning the qualifications of the candidates for the presidency of this country, which are constitutional requirements which have to be complied with. We cannot say and just dismiss the issues that I'm raising as irrelevant when they concern our constitution, which is voted upon by the people of Kenya, and therefore it is in the public interest. The issues here, I think, which you have to weigh is the issue of public interest versus private interest. The interests of the various petitioners seem to be private. The issues of the respondents of those particular petitions seem to be private. I brought these issues here before this court in the public interest, that the private issues which they haven't raised, but which the people of Kenya passed in the Constitution of Kenya should be considered, and therefore the matter be considered in the public interest. If the AG, who's supposed to be the defender of the public interest, hasn't raised the issues that I've raised, and our Constitution allows anybody, any Kenyan citizen, to raise these particular issues, I believe this court, being friendly to every Kenyan, irrespective of status, should actually admit this particular issue that I'm raising, that they be considered, dealt with, and we have a proper, validly elected president, fully compliant with all the laws of this country. There is no point saying we dismiss or accept this petition based on A, B, C, D, E, yet we know fully well, and your honorable judge is fully aware, the issues that are raised cannot be wished away. They should be considered in the public interest and in the interest of justice. And with respect to justice, this is the highest court in the land. This is where justice really ends. If justice won't be admitted or dealt with in this court, then where else in this land of Kenya can one go to for justice? This is a place for justice. I've come here, whether I'm a rich man or a poor man, is actually irrelevant. Justice sees nobody. Justice doesn't see a rich person or a poor person. It's the issues of law brought before this court that should be considered. And if public interest outweighs narrow private interests, and if the issues can be accommodated, just as petition in the same line as Petition 3, I believe this matter should be heard before the court and let the court make a judgment that will encompass all the issues of law that should be considered without ignoring basically the elephant in the room, so to speak. Thank you very much, Your Honors.
At 9 for your ruling, okay?
Thank you very much.
Okay. Professor Yashgai. Yes, it's...
I apply on behalf of the Katiba Institute.
Yeah, we wanted to know, Professor Yashgai, if that application has now been served on everybody.
Yes, it has been.
It has, okay, yeah. Okay.
Shall I continue?
Yes. Yes.
Katiba Institute was established about 2 years ago with the aim of promoting knowledge and enforcement of the Constitution. Since then, we have published numerous articles and held many workshops to increase knowledge of the Constitution. But more relevant for this particular application, the Katiba Institute has been admitted and acted as amicus curiae in a number of matters in the Kenyan courts, including the High Court, Court of Appeal, and the Supreme Court. For example, we were admitted recently by the Supreme Court of Kenya as an amicus curiae in advisory number 2 of 2012, a matter that dealt with the application of the two-thirds gender rule in Articles 27 and 81, as well as the interpretation of Article 1.4, which relates to petitions to the Supreme Court concerning a challenge of the election of a president-elect. Katiba Institute and I myself were amicus in the case relating to the determination of the dates for the general elections that was litigated in the High Court and the Court of Appeal and the Supreme Court. If I could briefly indicate the scope of our submission, which is now ready to be distributed, were we to be admitted as amicus, we intend to limit our participation concerning the matter at bar to commentary on issues of law, including the content, contextual and historical framework of the relevant constitutional provisions, the interpretation to be given to the various relevant constitutional and statutory provisions, relevant international and foreign law, and the range of constitutional and statutory remedies available to the court. I think that's all I need to say, unless you have some questions.
Yeah. Thank you, Professor. Mr. Regeru.
Yes, sir. Thank you, CJ. I've just been served with this application not too long ago. I've just been perusing it as Professor Yash Palgai addressed the court. And I think, in fairness to my clients, I would like to take a little more time. Why? To investigate whether there might be any conflict of interests with Katiba Institute. We do know that Professor Guy is a prolific writer, has written extensively, publicly, and so on. And I think, in fairness to my clients, we would want to dig a little deeper into the issue. Should we be satisfied that there is not any potential conflict, we'll be the first people to say. If there is a conflict, we will indicate to the court. And we can do this as early as when we resume fasting tomorrow morning.
When do you want to start the digging?
The moment we are released from here, we will begin to dig.
Tomorrow morning, that's what you're saying. Okay. Yes. Yeah. Ms. Kilonzo.
My lords and my lady, in view of your earlier ruling on the application by the Attorney General to be joined as a friend of the court and the principles you've laid out in that ruling, we will not be objecting to the application by Katiba Institute to be joined as a friend to the court.
Ms. Oraro.
I would really not object to the Katiba Institute being joined as a friend of the court, subject to very clear guidelines on what contribution each amicus can make to the court without interfering with the very tight program which you have.
Mr. Robello.
Your Honors, I would welcome the participation of Professor Yash Palgai, provided that there are very strict limits to his participation in view of the very strict and difficult timelines that we have. Perhaps if Professor Yashpal Ghai could limit himself to a written submission, a brief to the court, that might be very useful. I'm much obliged.
Senior Counsel Ahmed Abdullahi.
My learned friend who is assisting me in this matter will address the court on this issue.
No, he says yes. He says.
My Lord, the Chief Justice and the members of the court, I've also just seen this application now. In fact, I've borrowed a copy from my learned friend here. So we haven't been served with this application yet. The issues that have been addressed by my learned colleague, particularly the role that they will play and the partiality or otherwise that they will play in this matter is very crucial. And for that reason, I would want time to seek instructions from my client and respond to this, and therefore I think I will be able to do that in the course of the day, and then we'll address this issue tomorrow.
Yes, may it please you, my Lord Chief Justice, my Lords. Over lunch hour, I was served with a copy of this application. Invitingly, it shows an institution that has no partisan interest, but gone are the errors of first appearances. I request time to seek instructions from the third respondent as to whether this institute has undertaken any activity that would debar it from being an amicus. I cannot assume on face value that it hasn't. I would have no such authority. If you allow me that window, my Lord Chief Justice, by tomorrow morning, I'll indicate the third respondent's position, and if we have no difficulty, I'll indicate we have no difficulty. If we have, I'll present the material before the court.
My Lords and your Ladyship, I requested time also to take instructions. I will refer tomorrow morning.
So, Mr. Regeru, Mr. Ngati, and Mr. Keegan, you have the time. We can hear you tomorrow at 9. Okay? Thank you. We now hear Mr. Oraro's application.
May it please my Lord, the Chief Justice and judges of the Supreme Court, my name is James Ochieng Odwo. My Lord, before you is a notice of motion dated 19th of March 2013. My Lord, this application was filed on the 19th after the petition had been filed, and principally we seek disclosure of certain electronic logs. My Lord, I must confess that there's been substantial compliance with some of the things that we asked for, but there is still outstanding the electronic logs in the various servers that were used in the process of election. My Lord, if you look at page 28 of the affidavit of one Dismas Ongudi, there is an illustration of how the result management system was working. My Lord, Mr. Ongudi does not disclose empirically why the transmission system failed. But my Lord, all servers have got logs, and those logs will tell you if there's an error, the error will be noted. If there is an event log, it will tell you which event took place. And my Lord, if there is an error, that error will be classified and will be stated clearly in the log. So my Lord, we seek from the IEBC, as detailed in paragraph 2 and 3, and my Lord, their service providers, Kencall EPZ, Lantec Africa, First Technologies, Next Technologies, Google Kenya, all the logs of the various activities undertaken for and on behalf of the IEBC. My Lord, this request is not out of the blue, because the IEBC in its mandate has got a constitutional and statutory mandate to establish and conduct an electronic electoral system to comply inter alia with the principle of free, fair elections, which are administered in an impartial, neutral, transparent, efficient, accurate, accountable, and verifiable. So, my Lord, this is an obligation of the IEBC to provide those logs. My Lord, no prejudice will be suffered by the IEBC if those logs are provided. And my Lord, if you look at page 28 of the chart that I've referred you to, you will see that they had handheld devices which were connecting to the internet. Those devices have got IP addresses, or they've got media access control. My Lord, there are 6 servers which they used at the headquarters. There is headquarters server number 1. There is also another server at the constituency tally center. There is also another server at the county tally center. There is also the national tally center server, and then there is the backup. My Lord, all we are asking for are the electronic logs on those servers. My Lord, those servers will tell us whether or not there was a transmission through the service providers, what time it was transmitted, whether it was a successful transmission, whether there was an error, what was the nature of the error, so that we are able to verify what Mr. Ngondi has stated in his affidavit. That's my application, my Lord. I therefore ask, my Lord, that you allow prayers 2, 3 of the notice of motion that is before you.
I forgot to ask whether you served all colleagues there.
Lord, I did serve the application.
Thank you. Mr. Ringero.
Thank you, CJ. Although the orders sought are really directed at the IEBC and its chairman, in view of the consolidation of these proceedings, obviously we have a right to say 1 or 2 things, and we do have 1 or 2 points to make. And you do notice, my lords, that if you look at a wording of those 2 prayers sought, 2 and 3, they are to the effect that they be given all this information, or whatever they have limited it to facilitate a forensic audit of the first respondent's IT system prior to the hearing of the petition herein. So that is really the order that they want, to conduct a forensic audit of that IT system of the first respondent prior to the hearing of the petition. Now, the questions that must engage your mind with respect, my lords, is number 1, who is going to carry out this forensic audit? And let me say that these questions arise because you cannot possibly be acting in vain. You want to be making orders that are effective and productive and that are useful to this process. So legitimately, you would have to ask yourselves, who is going to be conducting this forensic audit? Number 2, who would participate? Is it only the applicants, their agents? Is it all of us? Which leads on to the 3rd question, which is, on what terms of reference would the forensic audit be conducted? And another question that naturally arises is, who would be bound, or would this court be bound by the outcome of that forensic audit, or what is its intended purpose? Because again, we don't want to be engaged in an exercise of futility. And finally, because everything here is time-bound, you would have to consider really what time is there between now and Saturday to conduct any kind of forensic audit, which has to be done and produced before the hearing of the petition. So we would have to first allocate time for that forensic audit, get whatever result on whatever parameters, then we begin to address the hearing of the petition. With respect, my lords, we do not have the luxury of time. Time here really is cast not just in stone, it is cast in steel. We cannot extend it. And from a practical, logical viewpoint, I do not see how these orders can possibly avail to the applicants who bring them at this 11th hour when we are at the trial conference. We want to get onto the substance of the matter. Interlocutories, this would derail the very elaborate timetable that you have so painstakingly set to ensure that, in fairness to your lordships as well, that there is enough time for us to articulate our cases and enough time also for you to consider and to deliver your decision. On those considerations, it would be my submission that these prayers have no basis, they have no merits, there is no justification why they ought to be given. They should be rejected, and we get on to the substance of the petitions before us. Thank you.
Ms. Kilonzo.
My lords and my lady, I wish to support the application filed, the first petition. My lords, part of the prayers in petition number 4, prayer number E, mirrors the order that the petitioners in the first petition are seeking. What is more fundamental, my lords, is Section 82 of the Election General Regulations Act that makes it a mandatory requirement of the electoral process for the Independent Electoral Boundary Commission to transmit results from the polling station to the constituency tallying office electronically. It's a mandatory requirement. In their replying affidavit, the second respondent admit that Parliament amended the regulations. The regulations that are taken to Parliament couched that requirement in permissive terms that they may transmit electronically. Parliament, in its wisdom, provided the word shall, making it mandatory. There are admissions before this court that that obligation was not carried out by the Independent Electoral Boundaries Commission in 55% of the polling stations. The issue of the electronic transmission of results is an issue in both petition number 4 and petition number 5, the first petition and the second petition. It is my humble submission that the reasons that the Independent Electoral Boundaries Commission have given for the failure of this system is not sufficient, and they are obliged under the Constitution to be accountable. That means responsible and answerable. Those logs that the petitioner is requesting for will go to show why there was that failure. And more importantly, if that failure, the question whether these logs should be produced and what the court will do once the logs are produced is independent. They cannot be mixed together. It is important that this evidence, which is material to the determination of this petition and which is in the custody of IEBC alone, should be produced for the court and Kenyans and the parties to inspect. That is all.
Thank you. Mr. Rebello.
Response for the IBC will be made by my friend, Mr. Nani Mungai.
Nani.
Thank you, my lords, the Chief Justice and members of the court. The IBC opposes the application. We have filed grounds of opposition and a replying affidavit, which was filed on the 23rd of March. The application before you is not an application seeking for logs, as has been characterized by my learned friend, Mr. Ochengo Duolo. The request for logs is just one of 23 items that are sought under Prayer 2. The request for logs is Prayer 2O only. What is the application before you? The application before you seeks first and foremost a forensic audit. Secondly, it seeks that the IEBC produce physically all the equipment that was used in the election. The phones, the 33,000 phones, the laptops for BVR, the 14,000 of them, the EVIDs, the electronic video identification devices, 33,000 of them, and all the servers that were used in the process. So when you go through the application, you will find that what we have been asked to produce in 2 days is the entire ICT infrastructure of the IEBC. Once that equipment has been delivered to the petitioner, they then seek information that will enable them to undertake the forensic audit. So when you look at the prayers that seek the MAC addresses, the media access control addresses, the IP addresses, that is the information that will enable them to access the equipment once it is delivered. And then they also ask for all the passwords. This is prayer number 2G. So essentially, they are saying, bring all the equipment, bring all the information that will enable us to do an audit, and then give us the passwords. They are not concerned with the actual data because the data has been provided. So in respect of the BVRs, what data did it have? The register. That has been already provided. In respect of the results transmission devices system, all the information that was transmitted, all of it from 14,000 polling stations has been exhibited as DO4 in Dismas Ongondi's first affidavit. So the data is actually there. The only concern they have is that they're saying, we don't know whether this data is actually the correct data. So bring all your equipment and let us then interrogate it. So for you to give them the information, that is the logs and the MAC addresses and the IP addresses, you need to give them the equipment as well to be able to undertake. So the first question that this court must ask is there a legal and factual basis for undertaking a forensic audit? And we submit that none has been laid. The second thing that you need to consider, my lord, is that a lot of the information that is sought is totally unnecessary and irrelevant to the issues in petition number 5. For example, they have asked for all the BVR kits, the ones that were used for registration. So the question you need to ask is, if they were brought before this court and given the passwords and you entered in, what will you find in there? You will find the raw data of the registration. But you not only have the raw data of the registration in the provincial register, which has been produced in court here, but also the certified one. So essentially they are asking you to audit the entire registration process and try and find out what were you doing with this particular BVR kit. Totally unnecessary and absolutely irrelevant to the entire process. The other point you need to consider is the dangerous precedent that would be given by this order. Essentially, you have a petitioner who has come and said, I lost the election, I think it was because the equipment may have been tampered with. So if you order that every time somebody loses an election and is dissatisfied with the result, they can order a forensic audit, the IEBC will have no equipment. Then there's a logistical issue. Where is this equipment that they seek? It is in 17 warehouses all around the country. This is the equipment that the IEBC uses for all its elections. If there's going to be a by-election, they will be using this same equipment. But they want all that equipment brought here for forensic audit, essentially destabilizing the operations of the IEBC. My lord, one then wonders, what is the motive behind this application? Because the information itself with regard to the elections has all been supplied. Form 33, 34, Form 36, the RTS data, all that has been provided. in my humble submission, my Lord, this is a sideshow. This is a sideshow intended to distract the court and the parties from the actual petition. And this is manifest from the fact that there's a very curious component of this application. If you look at page 15 to page 48 of the bundle, there's a brand new petition in there. There's a brand new petition that has nothing to do with the petition that you have here. Page 15 to page 48. Essentially, you have a notice of motion, and when you read the notice of motion, you can see it is anchored on this new petition. This new petition is essentially stating the IBC was obliged to undertake an electronic election. And because it did not do so, the entire process is invalidated. Now, that's not in the main petition. So you wonder, what is this new petition? When is it going to be brought? And I think my learned friend, Mr. Ngatia, said when he talked about a metamorphosing case, I guess once the data is produced and they've done the forensic, they will then say, now we have enough evidence to prop up this new petition. So my submission is that this petition is an indication as to what it is that this petition is application is all about. My Lord, my learned friend stated that the IBC is under a constitutional obligation to undertake an electronic election. There is no such constitutional requirement, and there is no such statutory requirement. There are only two provisions in the law that relate to the use of technology. Section 4M of the IBC Act and Section 44 of the Elections Act. And those two state that the IBC shall have the discretion to deploy technology in the management of the election. There is no obligation to conduct an electronic election. And my Lord, in our grounds of opposition, we have set out what are the processes of the 2013 election. And they are all manual. They're not electronic. People marked a physical ballot paper. The ballots were counted physically. So it's actually a manual process, not an electronic one, as they seem to suggest. And our submission is that the role of technology in this election was to add an extra safeguard to the entire process. And the forensic audit sought doesn't help in advancing that question. Let's take the case of the electronic voter identification devices. The affidavit of Dismas Ongondi states that the problem with those devices is that they were delivered late and they were not fully charged. Why do you need a forensic audit to find out that a laptop wasn't fully charged? All you do is plug it and charge it, and you will know that it wasn't charged. What you need to be concerned with is what was the impact of not using that device in the election? And we are saying that there was a manual process for identification of voters that was robust. So my submission, my Lord, is that this application is a sideshow and a distraction and should be dismissed. And our grounds have also, in our grounds, we've also dealt with the question of the CAN-call server. My Lord, that's another curious request. The allegation by the petitioner is that the IBC co-hosted its results transmission system with the TNA. Now, that is not true. It's an outright falsehood. The affidavit of Nicholas Nesbitt has stated what is it that IBC was doing. It had a call center that had nothing to do with the elections for queries. Where do I register? What is the procedure for registration? That call center was hosted. The results transmission system was a dedicated system that was not linked. By the time they had filed this, the affidavit of Nicholas Nesbitt was already on record. They knew that the call center had nothing to do with the RTS, but they've weaved a conspiracy theory around it. And that is, again, part of the sideshows that is being presented. So I would urge you to consider our grounds and the respective affidavits and dismiss this particular application. However, should the court feel that there is any document, any equipment in Prayer 2A, in Prayer 2 that is needed for the legitimate exercise of this petition, we're happy to provide the same. We're happy to do so.
you, Mr. Nani. Mr. Ngatia, I think you're next, right? Yes. Mr.?
Let me go first for the second respondent.
Oh, yes, yes, sorry. Yeah.
My Lord, this morning when I said the petitioner number 5 really doesn't know the main components of the case, my learned friend took offense at that. But I think really what we are seeing is that a clear evidence of an implosion in that petition. And what my learned friends are doing is a reconstruction of that case. It's a classic case of a fishing expedition, and like all expeditions, we really don't know where it will end. But my Lord, if you look at the notice of motion itself, I don't think that because this is the Supreme Court has powers to issue every prayer a party 6. The Supreme Court, like any other court, and my Lords, I will remind you, I think it's paragraph 65 of your judgment in the Masharia case, is that where a jurisdiction of the court is given, especially a constitutional jurisdiction, the court must limit itself to that. And I think the words you used that now has replaced the S.S. Lillian case. You said the court should not be crafty, the court should not be innovative when you are interpreting your constitution. But my Lord, if you look at this application, I don't think you have jurisdiction to grant these prayers. There is simply no jurisdiction. Look at the provisions of the Constitution this application is grounded on. The first one is Article 10. Those are national values. Can you give an order under national values compelling the first and second respondents to supply the IT system because it's part of our national value? I don't think so. Look at Article 38(2). It says fair, free, and regular elections. It has nothing to do with providing the issues my learned friends are seeking. The other provision is Article 35(b), right to access justice. My Lord, the right to access justice is a very fundamental right, but it must be court of first instance. You must go to the High Court. If you are successful, you come to the Court of Appeal, and then you can come to the Supreme Court. And my learned friends have made, not the petitioner himself, but his principals or his agents have made a similar application in the High Court. And my Lord, there is strike law. It's strike law. This court has said, and many courts have said, that when a party makes similar applications in 2 different courts with different jurisdictions, it is an abuse of court process, my Lord, and this is really what it is. So, my Lord, if you look at all those prayers, whether it is Article 82, 86, there is not one article in the Constitution that will empower this court to force the first and second respondent to give this power. This court, of course, has immense powers when a party rightly invokes its jurisdiction, but this is not one such case. You simply don't have that jurisdiction to compel. My Lord, if you look at the 2 prayers, and I associate myself with my learned friend Nani's submissions, I mean, the prayers they are seeking are really extraordinary. Look at prayer 2. That this honorable court be pleased to issue an order directing the first and second respondent, their services or agent, to deliver to the honorable court. To deliver to the honorable court and do what? When did the honorable court ask for these documents? And to all the parties in within 24 hours, all information, electronic hard copy in relation to the just concluded presidential election within. And my Lord, I think what my learned friend Nani says is very important. They have already all this information. They have been supplied with. What is the need for doing a forensic audit? Prayer 3 is more startling, my Lord. It says that this honorable court be pleased to issue an order directing the first respondent, servants, contractors, agents, service providers. You can't make order against the parties who are not party to these proceedings. How can you compel our contractors, our service providers, when they have not participated in these proceedings, to be compelled and to give orders? Google Kenya Limited, Next Technology, First Technology, Landtech, my Lord. My Lord, it's a basic principle of law that you can only make orders against parties who are parties to these proceedings. There are 5 or 6 parties who are not even aware. Of course they are aware, I'm sure they are watching TV, but who are not, but who are not aware really of the purport of the orders my learned friend are seeking. And my Lord, I think, my Lord, the court really should also see the real purpose of this. It's an attempt to cannibalize, to vandalize a national institution. When you bring all these documents from 35,000 stations from all over the country, how long will it take? It will take a month or two. We don't have that luxury. But my Lord, this application, as my learned friend rightly says, is premised on a false reading of the law. And that is a signature of this petition. When, for example, they say that the respondent was supposed to provide an electronic tallying system, my Lord, just look at page 52. My Lord, if you look at page 52 and see the grounds on which this application is premised on, ground number 2, Roman, ground number 3, ground number 4, ground number 5, and I think the most interesting one is ground Roman 14 at page 54. I mean, you'll be lost really about what the real intention of this. Look at 15 Roman when it says that the Honorable Court ought to be empirically informed of the real reason for the failure of the first respondent. My Lord, this is an adversarial justice system. It's not an inquisitorial. The court really has no role to play in this matter. It is for the petitioner to prove his case and the respondent is to answer. So, my Lord, my conclusion is this application is really an abuse of court process. Nobody, including, I think, the petitioner, really knows the real purport of this. And, my Lord, it ought to be dismissed so that we move on, especially in line of the limited time frame we have on this matter.
Mr. Gatia now. Huh?
My Lord, I associate myself with the submissions by my learned friends, but I have a few words of my own.
Which learned friends, including Mr. Odro?
No, the two learned friends, Mr. Ahmed Nasil and Mr. Nani. My Lords, as I understand it, a petition in this honorable court must be a structured and a targeted case. Targeted to a complaint which the petitioner identifies, and a complaint which the respondent is duty-bound to answer. It is not an open-ended grand Spanish Inquisition. It's a very targeted litigation. When it ceases to be targeted, one gets into the difficulties that we now have. I have looked at odd prayer number 3. Prayer number 3 is seeking every IT aspect of the electoral body to be provided parties and to be provided to the court. What is the nexus of all that massive technological components to the targets which are under inquiry in this case? What is the nexus of us having each and every device that was used to register 14 million voters? And I ask that because, my lords, there is the converse to it. When we get all that material of all the voters who are registered, and which we do not need for the targets that we have, we are also capable of mischief. Is it fair, my lords, for this honorable court to put in the hands of these litigants all the material of Kenyans that were obtained either in the registration process, the registration of voters, we know that's a figure of over 14 million, or the call centers that were received, there must be thousands of them, each and every aspect of that information For liars, my lords, it has not been demonstrated that that massive information has any nexus to any paragraph of the petition. It becomes therefore very dangerous, my lord, for very omnibus prayers to be made. They can be made in a very inviting manner. A very inviting manner, which the court says, yeah, there's no prejudice. Of course there is prejudice, because it's so omnibus, a prayer, and of course once that prayer is granted, parties are capable of a lot of mischief. Let us look, my lords, at the prayer number 3, perhaps a little bit more detail. I'll only take a minute or so. It seeks to compel companies which are listed and which are not litigants before you, to compel them to provide certain data. It will be a very odd day in a very advanced legal system as we have for an order to emanate from the highest court in our country, directed to a company which was not given an opportunity to be heard. And here I don't hold brief for any companies, but they may have legitimate concerns about releasing confidential information to the petitioner. They have not been heard. You haven't been told that any effort was made to serve this application on any of those companies. My lords, again, prayer number 3, you see all the items that are required, which my learned friend Nani says is in 7 warehouses. Whereas, again, the prayer is crafted in such a way that even the parties like myself or my client will be entitled to have access to that information. My lord, I do not see the purpose of that information when one remembers, as I started, that an election petition must be a focused and a targeted attack on certain complaints that the petitioner has and which are capable of being responded to by the respondents. In some, my lords, there is the aspect of proportionality. Every request as litigants come before you must be proportionate to what we intend to achieve. It will be very disproportionate to allow this omnibus prayer, while liars, there is nothing proportional to the information that will be gathered from it to prosecute the petition which is pending before you. I will therefore, my lords, request that you now direct us that we do not have the luxury of time. Each one of us could come with a very ingenious application, engage you unnecessarily. Let us now be directed to engage on the issues that arise from the petition, on the material that arise from those petitions, so that we can process these petitions expeditiously. That will be all, my lord.
Thank you. Mr. Kigen.
My lords and your ladyship, we also oppose the application, and we propose to oppose them on 4 grounds. The first one, my lords and your ladyship, is that the application is worded in a manner that is ambiguous and is infinite. My lords and your ladyship, looking at prayer number 2, it requires all information, electronic and hard copy, and it's bottomless. Prayer number 3, my lords, looking at page 50 to page 51, requires all access control, all media access control, and very significantly, prayer number D says, each of the laptop computers and or personal computers. My lords and your ladyship, when reflecting on whether or not to grant these prayers, there would be a consideration as to how you will enforce non-compliance in the event you grant the orders. And my lord, the difficulty of enforcing, for instance, the prayer for delivery of personal computers as sought for by the applicant, and the scope of what is used in prayer number 2, all information, electronic and hard copy. my lords, we argue will present insurmountable difficulty in establishing whether or not there has been compliance and whether or not there is contempt in terms of obeying the court orders. For the reason of its ambiguity and infinite nature, we pray that it should not be allowed. The second objection we have, my lords and your lordship, is that the application clearly, it merely says for audit purposes, both in prayer number 2 and 3. We submit that it is shopping and fishing for evidence. My lords, in respect to this issue of shopping for evidence, the first proposition we have is that it is an obligation on the petitioner before he determines that he has a petition to present to this court to have made up and define the scope of his petition. For him to subsequently come before you and say, assist me to get additional material upon which to mount my evidence, my lords and your ladyship, we submit is irregular and you shouldn't allow. The second one, and which is probably more important for us, my lords and your ladyship, is that if you are to grant the orders and the petitioner's petition gets improved by reason of the information and the material you give them, then my lords and your ladyship, you will have, in a certain way, assisted the petitioner against the respondents in an adversarial situation, my lords. And we pray that you leave us to our own devices and you leave us to shoulder our burdens of proof as is required in law. My lords, the third point I was to raise has already been raised, being that it is expected, my lords, that the natural justice rights of third parties will be respected, and the prayer in respect to third parties who have no audience before the court will not be violated by ground of the prayer sought. The fourth issue we wish to raise, my lords, is that the Constitution and the rules governing petitions have defined the scope of what is expected of the first and the second respondent to be presented in court. And that scope was consciously and deliberately defined, including Forms 34 and Forms 36. My lords, to attempt to expand the scope of what is required to be presented to this court, my lord, we submit would be to be innovative, to use the word of the second respondent's advocate, that you would be acting innovatively on the Constitution when it's not warranted. Lastly, my lords and your ladyship, we submit that considering the time constraints which were deliberately fixed in the Constitution and the rules, with the intention of bringing this petition to an end at the earliest possible moment, this application seeks to frustrate that object, and we pray that you shouldn't allow it. For all those reasons, my lords and your ladyship, we pray that you disallow the application.
Councillor Duo.
My lord, I must start by saying that all councils have miscomprehended what is sought in this application. But my lord, I'm not surprised because there's a big divide between the analog age and the digital age. I say so with respect in the following arguments. Lord, if you look at the chart that was given by IBC, the result management system, it's composed of various servers. All activities that were undertaken by IBC in the results transmission would be on their servers. So it is one central location. They have the server at the headquarters. That's where the logs would be. The only explanation we have from Mr. Ngondi is that there was a failure due to various reasons. That the people forgot their passwords, the system got jammed. But that's not empirical. The only way this court can be satisfied as to why the system failed is by those logs being produced. And look, they're not bulky documents. I started by making a concession that there have been production of a lot of documents. The Form 34 have been provided. The Form 36s have been provided. The Principal Register of Voters has been provided. The Provisional Register has been provided. The database as a result of the elections has been provided. My Lord, all we are asking for are the electronic logs. And my Lord, there are specific servers. The server at the headquarters where the results were being transmitted to. The server, which was the backup server. We have the server that was at the National Tally Center. We have the server that was at the County Tally Center. And the servers that were at the Constituency Tally servers. These are electronic logs which can be either be printed out and furnished to the parties. And my Lord, we are not fishing. Those are their own records that will show us why those devices failed. As we have right now, there is nothing empirical to show why those devices failed. All we have is the IT manager saying, look, there was a wrong installation, this did not happen, they were delivered just before the elections, therefore we were not able to successfully test those particular items. Whether or not they worked is an issue.
Is it being denied that the devices did not fail?
My Lord, it is stated that they failed to an extent. That is what is stated. But my Lord, that must be empirical. If the device did connect to the server and there was an error, what kind of error was it? That would be found in the electronic log, specifically the error log. If there was an event that occurred, it would be in the event log. And my Lord, more important, the archives of all these servers would have that information. My Lord, there is no reason why the IEBC or even the respondents who seek to know the truth of why the system failed should resist this application so vehemently. My Lord, on the third parties, like Kenco, they were all service providers to the IEBC. They did not have independent data. The data belonged to the IEBC, but they were providing a service to IEBC. For example, Google, if they were actually transmitting these results, from which server were they transmitting these results? What was the IP number of that server? That is all we seek to know. And we are very, very clear. We seek the logs, the IP addresses, the MAC, and if there was a transmission, that will be confirmed in the log. My Lord, I wish to end by stating this, that the IEBC is supposed to be a neutral party, is a custodian of information, and their obligation under the Constitution is to conduct a transparent electoral process, one that is accurate. They must provide full account of every failure or success. And my Lord, lastly, it must be verifiable. How are we supposed to verify the fact that there was a failure of an instrument if we are not able to dig out the electronic log and know exactly what the machine said? It's not a time-consuming exercise, my Lord. These logs can be downloaded in a matter of minutes. And there are only 6 servers that we are referring to as per their diagram on page 28. And my Lord, for the avoidance of any doubt, by their own chart, we have the server at the headquarters, we have the server in the backup, we have the server at the National Tally Center, the server at the County Call Center, and the server at the Constituency Tally Center. And my Lord, to the extent that they have admitted that there was a service that was provided by Kenco, a log from that server would suffice. My Lord, we are not looking for any equipment to be delivered, because if an equipment or a handset device communicated with the server, it would be there in the server. Those are my submissions.
Before you take your seat, as you're aware, we are supposed to rule on this latest tomorrow morning. So just to help me and my colleagues to appreciate the gist of that application, what point do you hope to prove by the forensic audit? What specific allegation in the petition do you hope to prove by this forensic audit?
My Lord, there is a specific pleading that the system has set up was set up to fail, and there was no intention to use the electronic means of transmitting the data from the polling station to the tallying center.
Question from me, Mr. Chengodol.
Yes, my Lord.
What is your response to the allegation that once you obtain this information, if at all you do, you have prepared what you possibly the other party is proposing to be an intended amended petition? What do you say to that?
My Lord, there is no intention to amend the petition. And my Lord, the rules don't allow it. The time do not allow it. All that will be able to show that contrary to the empirical information contained in the log files, Dismas Ongondi has not disclosed to the court why the machines failed, why the entire result management system failed. That can only be verified by examining those logs. We don't have to look at them. The courts will be able to look at those logs. The logs speak for themselves. It will tell you there was an error because, one, you did not punch in the right password. It will be an error because, one, there was no connection, or there was no attempt to connect from that device to the network at all.
One more question.
Yes, my Lord.
Once you have obtained that information, what do you seek to prove?
My Lord, you'll notice that we've listed down 2 experts to come and give evidence. And they'll be able to walk you through to tell you that this log says this. Contrary to what Mr. Ongondi says, this is what happened. There was a connection, there was a transmission, a successful transmission, or there was no connection. There was no attempt to connect or even transmit this result electronically. My Lord, from Mr. Ongondi's own affidavit, he says there was a 55% success rate in the connections. Where does he get that information from? Why doesn't he tabulate that evidence before us in the form of logs? They are not even annexed to the affidavit, other than a bare allegation that there was a 55% success rate. There is nothing empirical. And my Lord, once again, I wish to remind you that the IEBC is supposed to render a system that is accountable and verifiable. Lastly, my Lord, to put this in context, why is it that on the electronic display screen, the number of rejected votes was initially 300 and something thousand? Where was that data coming from? Does he explain how that transpired? It is only the log on that particular machine, on the display system that will be able to tell us what was actually happening.
Hello, just a clarification. That last question, the grounds of opposition deal with that squarely, and so does the first affidavit. Equally, on the 45% transmission, we have exhibited the results that were transmitted from 14,000 polling stations as DO4, the exact ones. And if you enter into that data, you will see each and every polling station and the results that were transmitted. We've also annexed a table breaking down those ones. So when my learned friend says that nothing has been given, it's selective. So what I would urge the court to do is please look at the grounds and affidavits, because we've answered all those questions.
The ruling will be delivered tomorrow. Yeah. Yes, can we now hear Mr. Gatti and Mr. Abdullahi on that issue of the affidavits? Yes, I have. Yeah. And then I have issues as well.
Yes, may it please you, my Lord Chief Justice and my Lords. I intend to present this application very briefly, and I hope in a more interesting manner. We start at the beginning. We should always start at the beginning. We are now dealing with petition number 5. In petition number 5, the electoral areas that are listed in that petition as the areas of controversy are actually 57. 57 constituencies are set out as the areas in controversy. That is amplified in an affidavit sworn by Janet Ongera, and in paragraphs 51, 54, 55, 56, and 57, she sets out all the areas in controversy. The controversies, my lords, I want to summarize this for you, if I could. For example, in paragraph 51, this is the affidavit of Janet Ongera in the petition. The complaint, and this is what I was saying, targeted complaints. The complaint is that the votes cast exceeded the number of registered voters. And that is a good engagement, because that's a complaint that has direct connection with the electoral process. In paragraph 54, the complaint is that there are discrepancies between Form 36 and the final results announced at Bomas of Kenya. Another controversy that we can engage in. Paragraph 55, again, a complaint about discrepancies in Form 36. Paragraph 56, discrepancy in Form 34 and 36. My lords are now quite familiar with these forms. Form 34 is the one that is issued at the polling station. 36 is the one that will be issued possibly at the constituency tallying center. Paragraph 57, results from Nakuru County are different from the results at the tallying center. And paragraph 60 are again material variations. All those are litigible disputes within an electoral process. In respect to all those, my lords, the third respondent filed an affidavit in answer to each and every allegation. We not only joined issue, but we gave a complete answer. And as indicated in the morning, my lords, and I need to say this for your record, the merit of the accusation, the sufficiency of the answer, those are matters which are in your hands. Suffice to say, complaints were made and those complaints were answered. That is where we started. This morning, my lords, a 900-page affidavit was served on my learned friend, Mr. Ken Ogeto, who is on record for the third respondent. It includes another affidavit of the same lady, Janet Ongera. It is paginated. When you retire to consider this very fundamental issue, if my lords could go to handwritten page 45, is a schedule, a new schedule of electoral areas, and the complaint this time is a new complaint, is that votes were inflated. Votes were inflated. And that, my lords, contains 58 new constituencies. 58 new constituencies. And even if there is reference to a constituency that was in the first document, this time it is in respect to a new polling station. Because again, my lords are now quite aware that in a constituency there could be even 120 polling stations. So each and every allegation here is in respect to a new complaint and a new electoral area. That goes on between handwritten page 45 to handwritten page 46. At page 47, again, complaint of results that were inflated, now comparing Form 36 with the final results announced at Bomas. That goes on, my lords, to page 48, and it goes on to page 49, page 50, up to, my lords, for brevity, page 54. In total, my lords, the new electoral areas are 122. With specific new complaints. And the question for determination at this stage would be, would this honorable court allow complaints made within time, responded to within time, to be amplified by other complaints made out of time, and which now will force us to respond, and in the process of responding, we respond insufficiently, and then what my learned friends will say is, in respect to the affidavit at page this, that response has not been answered. And it won't be answered because between now and tomorrow, or even the remainder of this week, it will be a scientific impossibility to respond to these new complaints. I go to the law, my lords. As I understand it, there is a specific timeline within which a petition must be filed. For my purpose, my lords, I understand a petition to mean and include all the allegations that the petitioner wishes to have canvassed in that case. It is not a petition part 1 and part 2, it's to be introduced later. It is the entire petition must be filed within time. My lords, within the limited time that we had, we were able to find an authority from Nigeria, the Court of Appeal of Nigeria. This is the case of we've now made copies available to you. If my lords could turn to page 7 of 11, the pages are printed at the left hand, at the bottom of the left hand, page 7 of 11, and then towards the top of that page, the Court of Appeal cited paragraph 16(1) of the first schedule. In Nigeria, unlike in Kenya, the rules are a little bit more elaborate. They provide that if a person in his reply to election petition raised new issues or facts in defense of his case, which the petitioner has not dealt with, the petitioner shall be entitled, my lords will notice the word, shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner's reply in answer to the new issues. So in Nigeria, it's very elaborate. A petitioner is entitled as of right to file a new affidavit if a new matter has been raised. We go to the second one. The petitioner shall not at this stage be entitled to bring new facts, ground or prayer tending to amend or add to the contents of the petition filed by him. So even in Nigeria, my lords, the petitioner at that stage cannot be entitled to bring new facts. We proceed. The petitioner's reply does not run counter to the provisions of subparagraph 4, and then the paragraph I was looking for, my lords. From the wordings of the above provisions, it cannot be disputed that a petitioner, like a plaintiff in a regular court, can file a reply or defense to meet fresh issues raised in a reply or statement of defense. What a plaintiff or petitioner cannot, and this is the important sentence, cannot do, however, is to raise or introduce yet another fresh or new extraneous something to those raised. I pause, my lords. A petitioner is not entitled to raise new grounds or raise new or fresh or extraneous issues to those he had not raised. And one sees the importance of that, my lords, because if the petitioner is to now be allowed by you, my lords, to raise another 122 new electoral areas, and tomorrow another set of whatever number, then there can never be a defense to this petition. It will be a petition incapable of being defended. Because at every turn of the day, new grounds, new accusations will be made. We go to where we started right at the beginning, the right to a fair trial. It is a right that the petitioner has, but it is a right that the respondent also has. The petitioner had the luxury of not less than 7 days to craft his complaints into a petition. We had barely 2 days to file a defense to those. To allow new complaints, new accusation, my lords, is not only prejudicial, but it will reach a stage that then this petition becomes incapable of being defended. As I indicated, my Lord Chief Justice, and this is not an exaggeration, it's not possible to respond to 122 new electoral areas in the next 2 to 3 days. It is not possible. We would have to look at all the votes cast at each electoral area, compare that with Form 34, compare that with Form 36 to have a meaningful response worthy of being tendered before you. It is not a defense of we deny. It goes beyond that, It is a denial, and more important, a narrative of why we are denying. We are denying because the votes cast were this, registered voters were this, rejected votes were this. That is how a defense in the Supreme Court must be made. I therefore request, my lords, to hold parties to their bargain, which is not to litigate in piecemeal. You litigate wholesale, you litigate with the petition that you filed. To allow this new petition to be filed, my lords, would be quite unfair. With those remarks, my lords, may I request that you disallow this affidavit. Needless to say, it was filed without leave. Even that courtesy of a litigant to seek leave, the petitioner thought it's not worthy of him. He filed this affidavit, served it on the parties, as if it's a fiat accompli, he must do what he perceives he is entitled to do. The days of any person thinking he is entitled to do things as of right are days of which are long gone. My lords, we all must submit to the jurisdiction and the powers of this honorable court and conduct our cases with the courtesy and the decorum that this court deserves. I would not have said all that, my lords, while it's something that I would, within tonight or tomorrow, have been able to respond to. But I am not able to respond to this affidavit within the time span that we have. Unless my lords have any questions, I rest my case.
Thank you. Mr. Abdullahi, I think you're next.
Yes, my lord, I associate myself with the erudite and lucid submission by my learned friend, especially on the facts. But my lord, as he likes normally to say, I have one or two things to say on the law. And my lord, I think the basic premise of my submission really starts with pleadings. And I think it is trite law that a party is bound by his pleadings. Whether it is in the Superior Court or a matter of the first instance in the Supreme Court, a party must be bound by his pleadings. In this case, the petition filed by the respondent in petition number 5. And I think petition number 5 raises a number of fundamental issues for this court. When will this case stop mutating, as I said this morning? When will it be confined to a certain perimeters all the respondents can answer to, and we go for trial? And I think that's the difficulty the respondents are facing in this case. My lord, Article 140 is very clear on when a petition is filed. It's a time frame the parties must adhere to. And my lords, if you look at the Supreme Court presidential election petition rules of 2013, they give a framework on how parties should conduct their response. And my lord, let me just take you through a little bit. Rule 2 talks about petitions generally. Rule 6 talks about the filing of petitions. Rule 7 talks about the service of petitions. And Rule 8, my lord, talks about response to petitions. Rule 8 says, upon service of petition under Rule 7, a respondent who wishes to oppose the petition may, within 3 days of service of the petition, file a response which shall it continues, my lord. And it says, P, it may be accompanied by a reply in affidavit. Then 2, it says, where the respondent does not intend, it goes on, my lord. Then, my lord, the next step is pre-trial. There is no provision in the rules of this for a petitioner to file an affidavit in response to the response by the respondent. There is no rule. But it can raise, my lord, that issue at the pre-trial, like the one we started this morning. If you look at Rule 10, it says, issues for determination during the trial. The court shall, at the trial conference, A, frame the contested issues, B,
consider consolidation. C, give directions. D, suitable directions. My Lord, look at F. Give directions in regard to the filing and service of any further affidavit or the giving of additional evidence. So there's a procedure, my Lord, because I think what the respondents are complaining about is the flooding of evidence without leave of the court, because it changes materially the case that is facing the respondents. If my learned friend will have come to the trial and says that this is the additional evidence we want to adduce, I think it's only fair for the court to invite all the parties and say that if the petitioner wants to expand his case this much, are you in agreement? And everybody will say either yes or no. But the flagrant breach of the rules by the petitioner, and I think my learned friend put it very well, like it is a fait accompli. He decides what to do. He files what documents he wants. He expands his petition as he wishes. I think it is an issue that raises a fundamental issue for this court. When will petitioner number 5 be restrained so that he acts within the confines of the law? But my Lord, as my learned friend rightly says, the case we faced when this petition was filed has changed significantly. We faced only 53 areas, we answered all of them. This affidavit has tripled those. Now, there is about 122 areas. What time will the parties or the respondents have to answer these questions? And isn't that a significant amendment of his course of action in a manner not provided for? Because he's amending his course of action. He's amending the petition in a manner not provided for through an affidavit. Can a petitioner amend his course of action through an affidavit? I think, my Lord, that is something for this court. I think that cannot happen. The petition cannot be amended surreptitiously through an affidavit. And as my learned friend rightly says, my Lord, this affidavit, which is filed in flagrant breach of the rules of this court, and I think, my Lord, let us hear this from this court. Are these rules to be obeyed, or parties can disregard when they want, and the court will pat them on the back, give them excuses? I think that's some of the issue you will have to address in your ruling. And my Lord, I think this should be the start of obedience of even rules. These are not technical rules. 159 will not come in. When everybody thinks that it's not a rule of procedural technicality. This is a rule of substantive justice. One party is taking the court for a ride. He does what he wants in breach of the fundamental rights of the other party. So, my Lord, my prayer, as my learned friend says, is that this court must exclude this affidavit, so that the petition we go for trial is the original petition that we were served 7 days after it was filed. The animal we are facing today is a completely different animal, my Lord.
Sorry, Your Honors, when this matter came up this morning, I was taken a bit by surprise because I did not know that there was a new affidavit which had been filed. I did check up subsequently. Apparently, an affidavit was left at the offices of my learned friend, Mr. Mohammed Nioga, when his office was closed yesterday on Sunday. And his messenger was telephoned and he was told, look, come to the office, we want to serve you with some papers. Mr. Nioga was in a conference with us at Utali College, so we did not know until very late in the evening that this affidavit had been filed. So if the court could give us a few minutes to address it on this particular issue. The address will be made by my friend, Mr. Nioga, who has been working on this issue.
My lords, my lady, I wish to associate myself fully with the submissions made by my learned friends before me, and wish to add as follows. But my lord, all the Form 34 and 36s were supplied to the petitioner before the petition was filed. They were served with all the requisite information, my lords, to file the petition. The normal assumption is that a party who makes claims in court must have supporting material at the very least to make those allegations. Lord, I may ask, is it a case where you arrest a person and go around looking for evidence to form the basis of charging that person in court? There is no dispute that the petitioner had agents in polling stations across the country who were supplied with Form 34. Further, my lords, the petitioner was supplied with Form 36 at Bomas. My lord, we then have an affidavit that has been filed, I don't know what, the 11th hour, the 12th hour, in the guise of responding to the affidavit filed in response by the first respondent. And in that affidavit, the petitioner is introducing fresh issues. I can't say through the back door, but perhaps through the back window, which form a different substratum, a different petition, and we are now being subjected, my lord, being distracted from focusing on the main petition and focusing on this affidavit that has been filed, which introduces, as my learned friend Hamid Nasser submitted, a new course of action. And therefore, my lords, it cannot form the basis of submissions by the petitioner that they were just responding to the allegations or to the responses by the first respondent. Not at all. It is a very clever way of introducing fresh issues. And clearly, the petitioner is engaging in a huge fishing expedition, my lord. That's all, my lord.
I see. Senior Counsel Raro.
First and foremost, I must say I am very surprised by the objection, my learned friends.
With your permission, my lord, I am part of the team that is opposing the application.
Okay.
I'm still learning.
I don't mind coming after him.
No, it's okay. Yeah, I'm still learning, so you go.
My lords,
yes.
Thank you, my lords. My lord, the first ground upon which we oppose the attempt to introduce the new evidence and to expand the scope of the petition is on the premises, my lords, that the affidavit was filed without leave of the court. And my lord, the argument that they filed it without leave of the court is secondary to the primary point that the law doesn't allow them to file at all the affidavit. My lord, in consideration of the two issues, number one, that there is no permission in law for them to file an affidavit, and secondly, that even if a window was allowed them to file the affidavit, they needed leave, we submit that the affidavit should be struck out, even if any accommodation is to be extended to them under the rules for pretrial for them to adduce additional evidence. It is our submission that it should initially be struck out for being improperly in the court record. My lords and your ladyship, we emphasize on the size and the volume of the, my lords, it is over 900 pages, and my lord, we pray that you find the conduct of the petitioners, the arrogant manner with which they filed the petition, and expect the rest of us to respond without having sought your leave and without having allowed us to have a say on their intention, my lord, to be an issue to be castigated. The second issue, my lords, is that there are very clear timelines, and those timelines must have been consciously formulated and must have been deliberately put there for purposes of expeditious disposal. The first timeline is the filing of the petition within 7 days, and the burden placed on the respondents to respond within 3 days if they are opposed to the petition. My lords and your ladyship, if you were to entertain and admit the additional evidence into the petition, my lords, the first thing you would be doing is you would be operating outside the law, because you would be allowing an element of the body of the petition outside the 7 days that was contemplated. The second thing, my lords and your ladyship, that you'd be doing is to allow the petitioners to have more than 7 days to present their petition, my lords. They were under obligation to present the full scope of their petition within 7 days. They did file that with a sampling of 56 polling stations. They had, according to the way they have presented their case, they had the additional 22 stations which they have introduced now, but they did not want to present it within 7 days. They had to wait until the respondents had responded to each of the 56 stations, my lords. And my lords, we also wish to emphasize that in our assessment, our response to the 57 stations which they had used to sample was comprehensive, was adequate, and completely displaced their petition. It completely displaced their petition. And as an attempt to salvage their petition, which had collapsed because they had used the samplings which had no basis, they had to go and bring 122 more in a very strict timeline where my lords have to make the decision within 14 days, in circumstances that will make sure that we will not be able to respond to 122 and expose their lack of any basis for the petition. And my lord, we pray that that mischief be noticed and should be discouraged, my lords. My lords, if you were to, for one moment, entertain the option of allowing the affidavit and the additional evidence to go on record, and were to allow us to respond, my lords, it is significant that you notice that you'll be allowing us to respond outside the 3 days within which we are supposed to respond to the petition. And so you would be practically rewriting the law. My lords, you would also be rewriting the law in the sense that on the 7th day, we are supposed to engage in the pretrial conference, which we are engaged in, and the new additional evidence distorts everything, including the agreed issues, the scope of testimony to be adduced, and the scope of the scope of evidence to be adduced. And my lords, we pray that the fact that this is an attempt, my lord, to have the petitioner have an opportunity to change their petition outside the law should be discouraged. The last two things, my lords, is that the petitioner who has introduced this affidavit up to this moment has not given any excuse in the introductory parts of the affidavits or in any other context as to why they chose to withhold these aspects of their petition, these 122 locations, why they withheld until they were outside the 7 days. And my lords and your ladyship, it is our submission that you are entitled to know, and you are entitled to exercise your discretion as to whether or not the reasons that could be the basis for that delay deserve your accommodation. The last point, my lord, is we are encountering a situation where the petitioner is presenting their case in installments. They come with 57 stations, They thought we wouldn't be able to respond to them. We successfully responded to them. They bring 122 stations, and they say we are not introducing anything new. We are merely explaining and expounding on our evidence. We are, my lords, on our part, strongly minded that we have to be allowed to answer to each and everything they say. If we were to arrive at an arrangement where we are to respond to 122 stations, my lord, there is no end to the installment conduct of these proceedings. After the 122, there is no knowing how many other stations they will want to introduce. And my lords, we submit that the clause of pleadings has to be, a line has to be drawn at the point at which the pleadings has to be closed and the hearing commences. We pray that the bad faith with which the affidavit was filed, the strict timelines that operate, and the lack of justification for having filed it be reasons upon which, my lords, you disallow the application, the additional affidavit and the additional grounds, and that you allow us to proceed with the petition as initially framed and as initially scoped.
Of the third petitioners. I'll be very brief.
I was going to call you after Oraro. You and Kev, is that okay?
My lord, I don't think he can be called after me.
Okay.
For two reasons. One, really, he is not a party to this and he's not been served with any documents relating to this affidavit. If your lordships want to hear him, really, I would not put any fiat.
Okay.
But I do think that, strictly speaking, her and my friend, with due respect, are not parties to this contest. This contest was between the parties in petition number 5. But I leave it to the discretion of the court. Whatever they think is convenient, I will reply when I'm asked.
Yeah, I think we should allow them to address us, because I think this contest goes beyond the parties that you talked about.
And because we have also consolidated.
Yeah.
I'm also obliged, sir.
It's okay. Is that okay, Judge? Yes. 2 minutes, Mr. Regero?
Yeah, 2 minutes would be sufficient.
Yes.
Be very brief.
Okay.
Firstly, as my landed friend confirms, we have not been served. I think in the interest of completeness and fairness to everybody, and now that these petitions have been consolidated, we need to be served. Although they shouldn't rush to do it this evening, it will be subject. The usefulness of that bundle will depend on your ruling. So if it should be admitted, then we should be served. If it is struck out, then we will save valuable time and effort. On the substance of this application, my lords, on my part, I would go on first principles. This, I think, is an outright issue. It is very clear. It is a distilled issue of law. And the first point is, do the rules allow that affidavit that has found its way into the record? Clearly not. If you look, and my landed friends have enunciated on this, I don't want to be repetitive. Nowhere but nowhere will you find provision for the petitioner to file the affidavit that they have done. And to add insult to injury, they don't even bother to seek leave of court if they deigned it, if they thought for a moment that there was necessity to file that affidavit. Connected to that, which is adherence to the rules, it is clear, my lords, that if there is one institution that epitomizes the rule of law and constitutionalism, it is this Supreme Court. You have been steadfast in your observation of rule of law. You have been steadfast in your fidelity to the law. We have seen your rulings, we have seen your decisions, we have seen the rules that you have promulgated over time. And the one common thread is that you are faithful to the rules and you will not allow casual approach to the rules that you have set so elaborately. My submission, my lord, is that do not allow the petitioners to lead you to relaxing that position. You need to be stringent on these rules. The moment you relax these standards, then we, the practitioners, we, the parties, and the cause of justice will be in jeopardy. You do need to enforce your own rules. You do need to enforce the Constitution and all the laws. Third point is that there is a reason why there is an order as to pleadings. It is not done for the heck of it. There is a perfectly good reason. And one of them, particularly when you have tight timelines such as this, is for case management purposes, so that we have all a clear timetable, we all have one bite at the cherry, not 2, 3 at the prejudice of the other side. We can prepare in time, and your lordships have time to deliberate. Now, what is happening is that that timetable is being scuttled by this petitioner repeatedly. They have no regard to the timetables and the rules that you have set. And the question is this court going to countenance that for a moment? Are you going to allow them to get away with it? Related to this is that there really has to be an end to pleadings. If you do admit this, it has been stated that the respondents in number 4 and 5 will need several days, 3, 4, 5 days. We put in not even an affidavit because it is a brand new petition. They now put in a response to that petition, possibly with affidavits. The other side then feels that maybe they need to respond to that response that has come in. My lords and my lady, where will that leave us? You need to streamline this, you need to focus so that we do this business efficiently. The other point is fairness to the other side. The net effect of these tactics, and I think they're deliberate by the petitioner, the net effect is to seriously prejudice the rights of the other parties so that we are not clear as to what targets we are bringing down. These are shifting targets. You think you have the target in your sights, you want to pull the trigger, it shifts. They bring 122 constituencies on top of the other 53. We respond to this. Before we know it, they bring another 60. Surely, in fairness to the other side, this cannot be allowed. In view of these submissions, my lords, I beseech you, let us be stringent, let us be faithful to our rules, to the Constitution, and let this the affidavit that has been filed in total flagrant breach of the rules be struck out, those volumes given back to them, and we get on with the serious business of the court. Thank you very much.
My lords and my lady, with your permission, I will allow my senior, Donald Dare, to address you on that issue.
Thank you very much, my lords, my lady. And because this is the first time I'm addressing this honorable court, please allow me to say good afternoon and to say what a pleasure it is and a thrill as a Kenyan lawyer, as indeed my colleagues, to address this court. My lords, my lady, we are constrained with the same challenges that my learned senior face, in that this application and these arguments that we have had arise out of Petition 5, in which we were not parties, and therefore the parties did not serve us. So all we could do, as my learned senior has also done, is to try and engage in some intelligent listening in the course of this afternoon. So we'll only be in a position to make some general remarks. And the first and probably the most important, my lords, my lady, I'd like to make is that, bearing in mind the ruling that was given earlier this afternoon by the learned Justice Smoke and Wanjala, I wonder whether we are not splitting.
It was a ruling
by the court and read.
I just read it.
Yes, much obliged. And read by learned Justice Wanjala. I wonder whether we are not splitting hairs. My lords, my lady, due to our interesting sitting arrangements, I'm neither able to write nor to type. I type faster than I write. But I think, and I'm sure that the court will avail us with the full ruling. But among the words that I had, summarizing the ruling, was scrutiny of all Forms 34 from each of the 33,400 polling stations, including those of the diaspora vote, scrutiny of all Forms 36 used by the IEBC in tallying the said Form 34s to establish the accuracy or otherwise, and comparing the numbers of registered voters in Forms 34 with those in the principal register. And there were other orders made with regard to the principal register and so on and so forth. So I wonder, my lords, whether or not, in light of that order that has been given, to which all the parties, including the ones that we represent, will be bound by and will adhere to, with much eagerness, that this is not splitting hairs. My lord, my sense of what has been said is that we need to distinguish between issue and facts. And my sense is that the issues that the petitioners, both the first petitioners and in this case the second petitioners whom we represent, the issues that have brought us to court are static. The facts, the evidence that is illustrative of these issues is what may have been added. But the issues that brought us to court are static. And I would just also like to point out that one challenge that petitioners have faced, that certainly the petitioners we represent have faced, is the extremely dilatory attitude and approach of the IEBC to providing information, to providing documents that are necessary, not just for the petitioners, but for every voter and for every Kenyan. And if it were not for that problem, I doubt very much we'd be facing this problem where people are trying to table to you all that they can get. Article 81E enjoins the IEBC to, among other things, be transparent, to be efficient, to be accurate, to be accountable, and 86 goes on to carry out its work in a verifiable manner. And it is the failure to do this that at least has led the second petitioners here. And we would not be surprised if the first petitioner faced the same problem, because in contradistinction to the provisions of Article 81, and this will come out as the case goes on, the process has been opaque, it's been clumsy, it's been inefficient, it's been inaccurate, it's been unaccountable to such a level that any result coming out of it is actually incredible. And that is the problem. In our case, in the case of the second petitioners, we only received the documents, Forms 34, Forms 36, the provisional register, the principal register, and the RTS database late in the evening of Friday 22nd. So those are challenges that we did face. So be that as it may, again, and finally, I take a different approach to that taken by my learned senior and my teacher, Ahmed Nasir, as to the application or otherwise of Article 159. And that is to say that in this of all matters, if in this matter that has animated and has grabbed and has caught the attention of all Kenyans, we cannot apply Article 159, in which one can we? Thank you, my lords.
If I may be permitted a short comment. He's made an allegation that the IEBC, which I represent, has been dilatory or dilatory. That is a lie. It's false. We had only 3 days in which to file our response. As soon as I was instructed in this matter, I issued instructions to the IEBC that everything should be made available to council, everything that could reasonably be made available. We worked overnight. We had teams of lawyers at Utali College, sometimes up to 40 lawyers, checking the records, putting them into all these disks and all this technology and making it available. We met the deadline within 3 days. So this young man should not look up Roger Tesaros, find a word like opaque, and find every other word that means the same, just to show off to this court that he knows a little English.
No, that's not fair to him.
Mr. Rebello, There's a question of decorum in court.
I appreciate.
If you are unhappy or you are very angry, don't pour it out here in court.
I'm sorry.
You must respect the counsel.
I apologize. I apologize. But a comment like that is deliberately intended to insult. And I'm sorry if at this late hour I lose my sense of decorum. We have been very peaceful here throughout. But when somebody stands up at the 11th hour and starts really challenging the conduct of counsel in this matter, that is quite improper as well. And I would have expected that the court would have stopped this young man from making those allegations.
Mr. Rebello, I think you are not making a new point. You already said enough. I think you could sit down so we proceed.
Thank you very much. I have much obliged.
Thank you, my lords. I do believe that as time goes on, the sugar levels are getting down, and hence the reaction of my learned friend. My lord, what Mr. Dare said is not unlike what we experienced. In fact, on our part, we had to go to court on a petition in order to secure the documents. And if he's not aware, we were given soft copies sometime around Wednesday, late last week, but the hard copies were only served on Saturday in the afternoon. Having said that, my lord, first and foremost, I must say I am very surprised by the application made by my learned friends, but it is understandable in the context of what they want to keep out, my lord. My lord, first and foremost, I would ask us to go through the rules. My lord, the rules were carefully crafted, but when you go through the rules, they talk about filing of a petition, that is Rule 6, and then service of the petition, that is Rule 7. But in filing and service of the petition, the rules don't talk about affidavit. They don't talk about affidavit at all. Then it talks about response of the petition, but in response in the petition, they talk about replying affidavit, my lord. But as is known in the practice of this court and any other court, whenever there is a replying affidavit, there is expectation that there will be a response thereto if required, if any matter is raised in the replying affidavit that requires response. My lord, the rules go at Rule 10 to deal, there is no other mention of affidavits, but at Rule 10, it goes to deal with pretrial conference, and in pretrial conference, it provides for give directions in regard to the filing and service of any further affidavits or giving of the additional evidence. My lord, creative interpretation, response to replying affidavit not prohibited. We begin on that. Number two, the choice a petitioner has is either to file a response within 3 days to keep within the timetable and give the court an opportunity so that when it comes to the conference, the court may be able to deal with it, or wait until the conference in order to ask for leave. We chose the former, and I think that was in the interest of these proceedings. And my lord, the most important thing in a proceeding of this nature is to take into account that this is a proceeding which is encapsulating the spirit of all Kenyans. And it is important, not only on our side, but on the side of my learned friend, to bring all the relevant evidence which may help your lordships at arriving to a dispassionate decision. So that the only issue which can be asked is that, have we introduced any evidence which is not in conformity with our pleadings in the petition? That is when there is a departure, and that is the route my learned friends have taken which is contrary to the actual station, the actual situation, my lords. My lords, therefore, I will start by going through the petition and show you what we have pleaded. And in that respect, I would like to refer your lordships to paragraph 5 of the petition. I'll just read it very quickly so that I don't take too much of your lordship's time. My lord, in paragraph 5, the petition deals with the issue of tallying, and it begins at 5.1 by pleading that the first and second respondent resorted to manual tallying, which was discredited and abused system resulting in the 2007 arising out of its lack of transparency, accountability, and has been the subject to manipulation by the first respondent's officer. Hence, the necessity to introduce the electronic registration and transmission of results. Then at 5.2, it goes on to say that among the glaring anomalies which were observed in the process of manual tallying from which the first respondent excluded the petitioner's agents were that the results were declared on the basis of unsigned Form 36, multiplicity of Form 36 and variance of entry in some constituencies, alterations on files, and brazen disregard by the first, second respondent of the entries on the files of the constituencies, which were eventually reflected in the final tally of presidential elections results and which were announced without signed verification from 34s. In many polling stations, the valid votes cast exceeded the numbers of registered voters, including, not only, but including. So a couple of polling stations were mentioned, which the respondents had dealt with at that time. Then 5.3 goes on to say, in specific instances, the results in Form 36 disclosed by the first respondent were materially different from the results that were posted in the final tally of the presidential results published by the first respondent. Again, an open pleading saying this included Webuye East and Webuye West. 5.4, there were several instances where registered voter numbers in polling stations were inflated in Form 34, contrary to what was contained in Form 36. This included, and the polling stations are provided there. Then, in quite a number of circumstances, there were more than 2 Form 36 reflecting different returns. This included the constituents as stated. In yet other, there were alterations in Form 36 without acknowledgement, including Kiamba and Limuru. A further analysis of the forms revealed that in certain constituencies, there were more valid votes reflected in Form 36, in Form 34, including Chemuse, Mwen, and Danimoy. In yet other stations, there were different entries in 2 Form 36 submitted in respect of the same constituency, for example, Madeira constituency. In yet the final published result, in yet another, the final published results were materially different from the results reflected in the county tallying, for example, in Nakuru, not to mention the material variations between the verbal declarations made by the various commissioners of the first respondent at the National Tallying Center, allegedly after verification of results, and the final figures which are set out by the first respondent, including those of South Imenti, etc. The above, and this was the conclusion, the above are but a few samples of the many anomalies which obtained as a result of the purported manual tallying. So that, my lord, there is no pleading where the specific number of Form 34s which were tallied had been presented to the respondents, and only that formed the case of the petitioner. The petitioner merely gave examples of places, a few places, where what he was claiming had been done, had occurred, and left it open to provide any other space, which if the respondents wanted to close that window, their option was by way of asking particulars of any other stations which have not been provided. But they didn't do that. Instead, they responded and in the response, they have taken the position, and that you will find in the affidavit of the second respondent, that their manual tally was perfect, accountable, transparent, and there was no mistake. In response to that, the petitioner has gone through the documents they have filed and disclosed in this court. The Form 34s which have been filed and disclosed in this court, and showed the discrepancies which are even in those Form 34s in this court. And it is the first time in my years of practice where I have had a party objecting to an affidavit analyzing evidence which is part of the court record. Nothing in this, in fact, the majority of this, there are only 67 pages of the various affidavits which have been filed, and I'll tell you what those affidavits are in respect of. The rest is an analysis of Form 34, which have been filed in this court. And in fact, which indeed, by your earlier decision, referred to by my learned friend, you have said that you are going to carry out an analysis by the court, an inspection, which we have been invited to, my lord. So what you are being asked is a party files a document in court and is saying, don't look at it, don't comment on it. Then why did they file it? And when we look at these documents, we find that by small tallies, there were additions of votes for one candidate, deduction for another candidate, which were in Form 34, but not reflected in Form 36, and not in the results. And when you take totality of that manipulation, you end up with a situation where the results are well below what was reflected to the public. And we are being told, ignore it, it is a new ground in the Constitution, although the whole Constitution is about voter registration, tallying, and results. That's what the Constitution is all about. The whole of this petition is all about. So that, my lord, first and foremost, the objection is of no basis, and it has been worded generally so that you are not informed as to what is contained in this affidavit. Number two, the only other affidavits which have been annexed to the response is an affidavit by Oduor Ongwen annexing proceedings in respect of a prosecution which was going on and involving Face Technology as it was being awarded a contract. And that was a prosecution in respect of Anglo leasing. And we are telling the court, is this organization transparent? This ought to have been disclosed. And that is in response to their lack of responding to the issue of opaqueness, which has been raised in the petition. My lord, yet another affidavit which has been annexed is an affidavit in respect of the application for disclosure of data which was part of the application my learned friend argued. But it was in response to the response of Ngondi and the response of, Nesbitt, which dealt with the issue of transmission of data which had not been dealt with earlier in our affidavit. And lastly, the only other affidavit which was included was an affidavit dealing with a comparison between the total number of voters in respect of the gubernatorial elections and in respect of the presidential election. So nothing new has been introduced by way of this affidavit, which is not in the original petition and which is not among the documents which are before the court. And our wonder therefore becomes, are these documents to be dealt with as merely exhibits introduced for the purposes of entertainment or were they for analysis, because we have analyzed them and we are being questioned for analyzing those documents. Finally, my Lord, it has to be taken into account that what the law objects to is the introduction of a new issue based on new facts. Evidence is not an issue, and there cannot be an objection predicated on additional evidence on an issue which has been pleaded. There can be no objection on that basis. Indeed, the authority my learned friends were relying on from Nigeria is completely to the contrary. It says, from the wording of the above provisions, it cannot be disputed that the petitioner, like a plaintiff in regular court, can file a reply or defense to meet fresh issues raised in reply or a statement of defense. What the plaintiff or petitioner cannot do, however, is to raise or introduce yet another fresh or new extraneous issues to those he raised. My Lord, we are not raising any issue. We are merely analyzing evidence filed in court, and we are making it easier by showing the areas of evidence where we have disputes. In fact, one area is where we find that from these polling stations, 11,000 votes have been deducted from what was balloted for the petitioner. We have to raise it, and it is before court. Lord, that is my humble submission. On those grounds, I would humbly submit that this objection has no merit whatsoever. The only conclusion I would make, my Lord, that if any leave is required, my Lord, we humbly apply that we be granted leave for this affidavit to be admitted, as really we cannot proceed with the petition where we put in evidence, the other side responds, and we are disabled from responding to their response, my Lord. Thank you.
On behalf of everybody.
Yes, I hope so. It's a joy to respond to my mentor and teacher, Mr. Oraro. My Lords, again, we start from the beginning. Rule 28 obligates a party who is filing a petition to do certain things. It's an obligation on a party to do certain things, which includes, which includes filing a concise statement or the grounds in support of that petition and all the arguments in support of that petition. It is actually Rule 8. It is obligatory in that sense that it's obligatory in the sense that it requires a party to bring forth his whole case. My learned friend is just about to get the rule for me. Yes, I think we now finally have it. Yes, rule number 8, a petition shall be in Form D set out in the first schedule and shall contain A, a concise statement of the facts, a summary of the grounds of the petition identified particularly from 1, the statutory provision under which the petition is brought, Roman 2, the extent to which the petitioner contends that the issue under review was based, then C, paragraph C, a concise presentation of arguments supporting each of the grounds of the petition, and of course the relief that is sought. From that rule, my Lord, or my Lords, it becomes quite clear that a petitioner is supposed to bring forth his whole case. It's the first time, equally, as Mr. Oraro said about his practice, it is also the first time in my practice I've heard that you can do pleadings by examples only. You cannot plead and say these are only examples. You plead your whole case. Having pleaded his whole case, then the next question, and the only question really is, how about the new electoral areas? The defense, as I heard it, is this. Because in the petition there was a general, then these other 122 electoral areas are only to buttress what was included in the petition. As the first line of defense. And the second line of defense being, no, we saw documents that were filed and now we are focusing on those documents. Both defenses in my submission are not available. The two defenses are not available for one simple reason, that the new complaints are fresh complaints. They cannot be ignored and said because he said includes, it means they are now included in what the petition had referred to. As a matter of fact, my lords, when you retire, I request you to do this. To read the petition says there was malpractices in these areas, which includes this. But the affidavit by Janet, which is part of the petition, specifies all the electoral areas which were the subject of the complaint. And if, my lords, from your perusal, you find that actually that is the correct factual situation, then ipso facto, it will be that the new electoral areas are fresh complaints by the petitioner. And being fresh complaints by the petitioner, it becomes prejudicial to the other parties to be called upon to answer to the new complaints within a night or within hours as soon as we leave here. My lords, I go to the second response, which is that the issue, the evidence has not changed, and the issue is static. The less I say about it, the better. Maybe I deal with the accusation that IEBC is opaque. Only with one sentence, my lord. The Form 34 and Form 36 that were given to the petitioner were given to the petitioner simultaneously with my client. We were both entitled to those documents. We received those documents on 14th March. Simultaneously, those documents were uploaded on the IEBC website. In other words, my lords, a person following this case in Papua New Guinea can see all the Form 34s that were used in the last general elections. Despite that, an accusation is made that this body is opaque. It is a contradistinction. It defeats my sense of opaqueness if you can say that somebody who has uploaded all this information, given all the information, and still accuse him of being opaque. That only needs to be stated to be rejected. Second point, my lords, or third point, the application that was made for leave came far too late. In the sequence or in the scheme of Mr. Oraro's arguments, that was the last application or the last sentence he made, very reluctantly. I come from the school of thought that court rules are not made for jest. They are not made as a jest. They are made to be complied with. You must have seen the reluctance to request leave. It was the last sentence by my learned friend. But I go further. After having argued my application, it is really not open for that application to be defeated because Mr. Oraro belatedly sought leave. Particularly when it is understood to all of us as your practitioners that he could have sought leave informally pursuant to the rules. He had the right to even seek leave informally. He opted not to do so. And as I come maybe to the end of that line of arguments, was he obligated to seek leave? I look at Rule 8 of your rules, my lords. It says, under subheading further pleadings or affidavits, a party may, with leave of the court or with the consent of the other party, lodge further pleadings or affidavits. And that really is not something that is difficult for any one of us to comply with. What do I make out of all this? At this early engagement, my lords, it's important that the rules of engagement are clearly understood. Because if they are not understood, we will not have an engagement that has the parity of arms and the fairness that we all expect from you, my lords. The parity of arms and fairness would have dictated the petitioner to have put forth his entire case within the 7 days. And for the respondents, if they wish to defend it, to respond within 3 days. There is no other avenue open to bring new claims or new complaints. By allowing new claims or new complaints, my lords, the rules of engagement become changed in favor of one party and to the prejudice of the other party. My lords, it's with as much humility that I ask you to implement the rules of engagement, because anything less will lead to a very one-sided engagement. My lords, I request you to strike out this affidavit. Really, there are 50-something electoral areas which are fully covered in the petition, and which some of them are covered in the ruling that was delivered by this honorable court suo motu. Those electoral areas are covered in the electoral areas which are in the petition. Consequently, even for your case management, you need to look at the new 122 and see whether you make similar orders as you had done this morning. It will be quite unfair to go that route. Unless you have any questions for me, my lords, that is all, and I really request that this be expunged from the court record.
Thank you, my lord. Lord, my learned friend submitted, that's Ms. Oraro, that they are merely responding to documents that were filed in court after the petition was filed. My lord, the correct position is this, that the Form 34 and 36 was supplied to the petitioner before the petition was filed. And they were filed in court after the petition was filed. But again, more importantly, we were not ordered, as they allege, to supply the petitioner with Form 34 and 36. We actually offered to supply them after they filed their case before the time indicated in their demand letter expired. And we allowed them to photocopy those forms before they filed their petition. I just wanted to make that clarification because, my lord, there's a little confusion about it. Much obliged.
That is the unfortunate thing with adducing matters of fact in court. We disagree, and my other friend who was doing the case in the High Court is here. But I don't think that is a major issue. My lord, what I would like to clarify is the rule my other friend, Mr. Ngatia, refers to, Rule 8, which requires a party with leave of the court or with the consent of a party lodge further pleadings or affidavit, is the court rules of the court, not presidential election rules. So I just wanted to clarify that, my lord. Thank you.
So we'll deliver a ruling tomorrow on this matter. Ms. Kilonzo.
before my learned colleague submits. When my learned colleague was on her feet earlier on during the day, I had not seen the application that she was referring to. When the court rose earlier on, my learned friend served me with a notice to produce. My lords, in my understanding, a notice to produce is served on a party under the provisions of Section 69 of the Evidence Act, where a party is saying that they have secondary evidence that they want to produce, and they're calling upon the party to whom the notice is served to produce the primary evidence. My lord, I want to put it on record and perhaps save a bit of judicial time that the Commission has no objection to Ms. Kilonzo producing the secondary evidence that she has.
My lords and my lady, I think Mr. Nyamodi misunderstands the nature of the proceedings before this court and the conduct of an election petition. My lord, if you allow me, I would like to argue my application and he can respond to that application. My lord, the notice to produce is dated 25th of March 2013. I have cited various provisions of the Constitution, the Elections Act, and the Elections General Regulations, and the Elections Registration of Voters Regulations. In the petition, in the second petition, the first prayer, my lords and my lady, is that in the absence, a declaration that in the absence of a credible principal register of voters vitiates the validity of the presidential election. My lords, we seek that the Independent Electoral Boundaries Commission produces the marked register from each polling station. The complaint, both in the first petition and in the second petition, is that in the compilation, certification, gazettement, and the use of the register of voters, the Independent Electoral Boundaries Commission contravened the Constitution and the law. My lords, Article 38 of the Constitution is very peculiar. Article 38, sub-article 2, provides that every citizen of Kenya is entitled to a free and fair and credible election. Article 38(3) states that every...
But I think for everybody to follow, can we know what application is being argued? We have not seen this application. What is it she's arguing really?
My lord, yes, we have served.
An application? Application dated?
No, it's not an application, my lord. It's a notice to produce.
Is it an oral application? I think, let's be very clear. If she is arguing an oral application, she says she's arguing an oral application.
My lords, my senior will have his time to respond.
No,
it is my time to argue.
Have you served whatever you
yes, my lord.
Raising?
It is my humble submission that this court, as the court conducting the presidential election material, is entitled to the primary election material that was used by the Independent Electoral Boundaries Commission.
But,
that includes...
Ms.
Yes.
Kilonzo, I'm just asking you whether you have served everybody, because that has been the practice so far.
Yes, this afternoon. This afternoon, in fact, the notices to produce are here. I can see so many copies. It is right here. My lord.
Yes, please.
No.
Can you listen to Judge?
Okay, I would like to say something before we continue. I think there is a small miscommunication. Perhaps we should have made it elaborate. Time is of the essence. And every step you take must be clear to everybody, and everybody must know its consequences. So we saw the notice to produce, and we wanted counsel to explain to the court the purpose of the notice to produce, because this is not an ordinary civil litigation, whereby you can do these things at the time for directions in the normal course of a civil action, and where you have a lot of time. And there are consequences that arise by even failure to comply with the notice to produce. Because of the perception we have that this notice to produce can have an impact on the time, and actually, and the way we understand the marked registers, what they mean, and our apprehension that it may have a consequence on time, we thought this should be discussed by council.
Thank you, my lord, for those directions and your guidance. I believe I can proceed.
Is that clear to other council?
Petitions are consolidated. Whatever any party does, it's only fair to serve everybody else, so that we are not caught by surprise. And of course, for good reason. If you are to make a determination, for example, that there wasn't a valid voters register, one of the casualties of that would be my client. So it's important that the rules of engagement are clearly understood. My lords, Mr. Ogeto, who is right over there, who is the advocate on record, and myself have not been served with this notice to produce. Mr. Nyamodi has now given me this copy. It's not fair that these things are done casually. Let's serve. If there are arguments to be made, they are made when every party has notice of what is being argued. As to whether one can mount arguments about a notice to produce, I would have tremendous difficulties, because as of now, we do not know whether the person addressed will produce. It cannot be assumed he will not produce. But that is a side issue. The correct issue is that we have not been served, and I would want to participate in the argument, participate effectively, not by a sideshow of being given a copy by the advocate who is on his feet.
My Lord, can I address the court also a little bit? My Lord, I think if the court really wants to open the floodgates, I think you should open it wide. Yes. Because if my learned friend can, for example, argue such a substantive issue on this document when she has served nobody, I mean, you're opening the floodgates. We will come with all frivolous matters. And I think, my Lord, my learned friend rightly said, let us conduct this matter pursuant to the rules of this court. And this application, I've just seen it, does not cite even one rule of this court. I mean, it's been argued like it's a matter in the High Court, and she wants to proceed with it without serving any of the parties. It has a grave consequence, my Lord, if it's had. If we want to move orderly, I think let all the parties observe the rules of this court.
I think initially, and that was 20th, was it 20th? I think it was 20th when we had a mention.
Yes.
Although we didn't order, but we made it very clear that these documents are served, whatever their merit, but let every council look at them, because this petition is not about two parties. It's about 40 million people. And every council who is here must be heard. And that's why we've been very flexible in actually asking people to respond to applications that they have no direct interest in. So I think in your case, you said you have served. They're saying you haven't served. Make sure you serve them now, and we'll probably hear you tomorrow.
Okay. My Lord, I don't wish to interrupt you. But
it's okay, you can.
Yes.
Yeah.
According to the notices we were served, the respondents have 3 advocates. Mr. Ogeto. Service, is there an obligation to serve every lawyer who is in court when there's a firm on record? My Lord, this afternoon we came with that notice to produce, and I can tell you that Mr. Katwa was given a copy, Mr. Nyamodi was given a copy on instructions from Mr. Rebello and Mr. Ogeto. was given a copy. Surely, that's service. My lords, the first and second respondents have 13 firms on record. The firm of advocates that I chose to serve is the senior most advocate on record, and that is Mr. Rebello.
We assume that you serve, they haven't read, they want to read.
Yes.
Is that okay? We do it tomorrow?
I have no problem.
In the interest of justice, so that...
Yes.
But you're sure you served everybody? Because they are saying they haven't been served.
I served the advocates on record. I cannot serve Hamed Nasir Abdullahi, Mr. Ngatia, Mr. Karori, Mr. Njoroge Regeru. Surely, I can't make 13 copies of the notice to produce when it's only one party. The advocates for the respondents should set their matters in order and tell us who it is that we should serve our documents, because we can't be given that obligation to serve each and every of them. That is all.
If I may again, my lord, I have had a look.
Yeah?
I've had a look at the notice to produce, my lord. And with due respect to my learned friend, it cannot form the basis of a hearing before this court. If my learned friend seeks certain information, let her make a formal application. Let that application be supported by an affidavit to which the parties before this court can respond. The notice to produce cannot form the basis of a hearing.
That's a technicality. I think let's look at substantive justice in the matter, right? Everybody is just saying that they want to see it. That's what I understood Mr. Gatia to say, Mr. Abdullahi. And we of course hear the arguments about rules, but if you get it and you can make the kind of arguments you're making tomorrow, and we dispose of it.
My lord, perhaps maybe then may I seek leave to file a formal replying affidavit in respect of the notice to produce.
Mr. Nyamudi, sorry.
For purposes of movement, and we have no time, I think what the court is saying is that that notice to produce, or by whatever other name it may be known, has to be served upon each and every advocate. We are not serving firms. And then we are saying that come first thing in the morning or second thing, you will argue that notice, but the respondents will have the right to make a response, including the type of argument Mr. Nyamudi had just made, and this court will rule whether in fact that notice to produce has the effect which Kathy wants it to have. And then we move on, because there is simply no time. That is what we are saying. Is it understandable now?
Just one thing. Yeah, just one thing. To add to what my brother Justice Njala said, I think the way I understood it, and perhaps we all understood it, sometimes you could tell us whether we are on the wrong track, was that a notice to produce has been filed. We are coming for pre-conference trial, pre-trial conference, to set up the management of the case, to set up the cause and management of the case. We didn't want parties to be taken by surprise, or for documents to start being produced and issue of production being argued in the course of the trial. So we thought we put this as one of the checklists. Will anything arise from this notice, which has been placed on record? And then, so that now, if anybody wants to say something, we now, it's not strictly speaking an application. We all know that it's not an application. But then, if it's going to impede or interfere with the course of the hearing, we'd rather deal with it at the pretrial conference than later. So that if it can be, if Mr. Nyambodi, for instance, would say that I have no objection I can produce, so long as, for instance, he has that option, so long as it doesn't interfere, or it doesn't interfere with the, or it doesn't protract the trial, fine. But of course, we realize that possibly this could also cause an interference with the time. Perhaps other objections could arise. We thought in good faith that we deal with that now than later. We're not treating it as an application. So there'll be no requirement to put in replying affidavits.
I think we are happy to be guided by your clarifications, only that there is that little additional burden on us to serve every lawyer present, because from the quorum you will notice that we are 4 of us appearing for the client Kathy is talking on behalf of. But even as we sit here, the documents that have been served this morning, the whole day, they haven't served me and I've not complained, because I appreciate that once Kathy gets it, we have gotten it. So, and we don't represent big clients. They represent the clients who can make photocopies of these documents. However, in the interest of time, and because it is in our interest that we started the hearing of the petition even tomorrow, we are ready and willing to make photocopies and serve these colleagues who are here, if necessary, if we can find a photocopying place this evening. Thank you.
We'll take up this matter tomorrow morning. For 15 minutes should be enough. Yes, all of them. All of you, yes. So, the last thing that we want to do, and of course we are continuing until midnight, so you let us know when you want a health break. The last thing, anyway, is Mr. Ngatia, did you host your colleagues and are we agreed on the issues?
Yes, pursuant to your order, my Lord Chief Justice, which made me go out of pocket substantially, we had a very healthy engagement at one of the establishments. We actually saw that we ought to be talking about 4 issues, maximum 6 issues for trial. We agreed at that broad consensus that there will be 4, maximum 6 issues. We were able to draft issue number 1 and issue number 2 and substantially the other issues. I cannot stand before you, my Lord, and say we shall all agree. But at least we have agreed that will minimize the issues, because the more issues we have, the more of a burden we place on your shoulders. So my request, my Lord, is allow us more time until tomorrow morning. If in the course of the evening we find we can't agree because of adjectives and verbs, then we shall agree that we each file our own set of issues, and then we of course agree it is the court that would determine the issues. But I trust, my Lord, it will be more of semantics. It is not anything substantial. And in all probability, we'll be able, Mr. Oduol came up with a very good idea, and I'll try to, we shall try to advance that idea. And if our other colleagues agree, then we'll have a joint statement of issues. So that is on course, my Lord.
Have you agreed on who is buying drinks while you finalize?
No, it's got to be another person. It's Oraro. He's our senior.
Okay, tomorrow. So, sorry, I had said that was the last issue. Actually, it wasn't. We will very quickly hear Judge Joki on the time. You remember you told us how much time you need, and we have considered that, and we will now allocate the times.
And then from 10:30
to 11 a.m. is a health break. 11 a.m. to 1 p.m. we come back to court. We then break for lunch 1 to 2 p.m. Then at 2 p.m. we'll proceed until 3:30 p.m. when we take another tea break. And then we will work from 4 to 6:15 p.m. We have assessed the amount of time that we have because we would like to sit for the hearing in 2 days. That is Wednesday and Thursday. And we want to allow for time for consultations among yourselves as well as deliberations among members of the court. And therefore, we have said that we will sit for 7.5 hours, or 7 hours, 15 minutes per day, each day. And what we have done is to equally divide that time between, on the one hand, the petitioners, and on the other hand, the respondents. And we have said as follows, that the petitioner in petition number 3, we shall allocate 54 minutes. The petitioner in petition number 4, 54 minutes. Out of the, you see, we have 15 hours in total, the 2 days. So we are now dividing that into, in what we have seen. Huh? Sorry, is it? Can you hear me now? Oh, okay. I thought I could be heard anyway. So petitioner in petition number 3 gets 54 minutes. Petitioner in petition number 4 gets 54 minutes. Petitioner in petition number 5 will get 2 hours and 6 minutes. The first and second respondents will share 2 hours, 6 minutes. If they feel like using the time separately, that gives them 1 hour, 3 minutes each. If they combine, they have 2 hours, 6 minutes. The third respondent has 54 minutes. The fourth respondent has 54 minutes. And the Attorney General has 30 minutes. How you manage your allocated time is up to you. You will determine whether the time is to be used in submissions or you're going to produce your witnesses at that time. We have arranged a time management system. You notice that we have a stopwatch in the court. There is one on this side, there's one at the back, and by the time we start on Wednesday, there will be one in front of the Learned Counsel. And the stopwatch will start flashing as you near the end of your time so that you are able to wind up, so that we do not stop you abruptly. And we try and keep this time so that we allow each party sufficient time to contribute. We have very little time, as you all know, and if the President of the Court allows, perhaps we can extend, but we would prefer, in order to allow also the court time to deliberate, that we keep to this schedule. I think that's it.
So we adjourn until 9 a.m. tomorrow. Yeah.
This is not really, this is not really an application but a request. If you could perhaps reconsider, as I heard, the petitioner, particularly petitioner 4, will have 54 minutes. Petitioner 5 would have 2 hours and 6 minutes. And I'll have to defend that case within 54 minutes. My lords, if you could perhaps relook at it, because even if I were to say only one word in respect to each allegation, it will be impossible to do so. I have to meet the case by petitioner number 4, petitioner in petition number 4, and petitioner in petition number 5, and they have been given, one has been given 54 minutes, the other one 2 hours, 6 minutes. A lot of that time would be things that do affect my client. It won't be possible to really respond to all those accusations within 54 minutes. If it is possible, my lords. But this is something that we could look at tomorrow. I'm not asking for an instantaneous answer.
Like I said, we have 15 hours. Those 15 hours are divided equally between the petitioners and the respondents. Perhaps you can consult with the other respondents, and maybe those who don't take up so much time can donate some time to you. But otherwise, we don't know where we will get the time from.
We could deduct from the fifth, Mr. Oraro's 2 hours, 6 minutes.
Mr. Ngatia. Mr. Ngatia. Sorry.
Yeah.
You're still on. You're talking.
Say something.
Yes,
very briefly. Actually, the pre-trial conference is actually a dialogue. We are not making orders.
Yes.
So this is the proposals we're making. And if you have better or rather suggestions, like even cutting down on the tea breaks, please tell us.
On my part, my lords, I'll do anything possible so that at least I have some adequate time to respond. Because what I see is from, say, my learned friends, they'll make quite a bit of accusations that will need to be responded. But, my lords, as I indicated, this is not an application, and from the what I have now learned, it's still subject to a bit of adjustment. What I'll do is I'll also engage with my learned friends and see a very fair way of apportioning all the 15 hours that we have. Yes, which may include actually not having very elaborate tea breaks.
I don't know what the status of written submission is going to be, because perhaps that is one way of cutting the time that we are looking for, because we may not be able to go through all decisions that we're going to cite. But if then we are allowed to file those submissions perhaps in the course of tomorrow or after that, then that can help in expediting the matter.
Yes, my lords, I have something small to say too. A couple of things. One is that I think the court has treated us as equal on account of being persons, rather than on the substance that has brought us before you. Because the issue, especially related to petition number 3, is only one, whereas the other petition number 4 or 5 have more issues. Therefore, that equality is actually breeds inequality. 2, we will need the right of reply, I hope, and the way the time has been distributed, I humbly suggest that probably that, I don't know whether you took that into account, because we will be waiting. We might spend our 54 minutes in our submissions and witnesses, then we will not have the time to reply after they have said what they have got to say. 3 is that the 3rd and 4th respondents, I will treat them much the same way I've treated the 3rd petitioner, because most of the allegations, at least our client makes, are allegations against the 1st and 2nd respondents. And therefore, treating them, if you look at actually the way time has been distributed, the petitioners have much less time than the respondents have, yet it is the burden of proof, it rests solely with the petitioners to show cause that they have a good complaint they have brought. So I think, my lords, it is something that we need to consider. Kathy and I believe all of us, are willing to be with you until midnight every day, so that we finish this matter. However, we appreciate the other constraints. But perhaps what we could do is, considering these comments we are raising, we can reconsider this timetable tomorrow. Not to reduce the number of health breaks, but to weight each of the parties so that we have sufficient time given to the parties who have the burden of proving their case before you, rather than allocating about 6 or so hours to, maybe more than that, to just one side and much less to the other side. Thank you very much.
My Lord, I have something small to say on time allocation, especially in petition number 5. And I think it will be fair to all the parties if we know what is the basis you allocate. Is it 2 hours and 6 minutes to the petitioner? If it is the volume of documents, we want to know, for example, if it is the volume of documents, because the first and second respondents have the largest volume of documents. If it is the weight of the matter, I think we need more information really on this matter, because the first and second respondents, who are the Electoral Commission and the returning officer, cannot be given 1 hour or 50% of the petitioner when there are two distinct parties with distinct set of advocates. We need clarification on that, because as we have been saying the whole of today, there must be fairness, even in time allocation. If you give a party 2 hours and you give the other party who is answering that same question raised by that party 1 hour, I think you are sending a signal which is not good for the hearing of this case. Let us be fair to the parties. I will suggest like this. If it is, I think we have 14 hours, 15 hours, let us divide it equally between the parties. You can't give certain parties preferential time. It's not just fair, because everybody will see that it is not fair to my client when I'm given half of Oraro's client. There must be a formula, and you must share with us so that we buy that formula. If we don't buy, we see the court is not fair to some of the parties. And I think it's very critical. If you limit the time you give us and expand or give one party unlimited time, of course the case is already prejudiced against some of the parties. So let us have a formula that's agreeable to all the parties. Yes, divide by the number of the parties.
No, that's your formula. We want to give you our formula.
Yes, yes.
and then we can debate around that, right?
I think
yeah.
This is our formula, which we are giving you. We are giving you our formula, and then perhaps you can make proposals, or after you've discussed among yourselves, you come back with another formula. But this was the formula. We have 15 hours. We have divided the 15 hours in half. Half for the petitioners and half for the respondents. So that when you're looking at your time is coming in the half given to the respondents. Then within the respondents, we have divided time, so that the first and second respondents have 2 hours, 6 minutes together. If they want to argue separately, they have 1 hour, 3 minutes each. That's because in our assessment, their pleadings are closely related. Then we have the third respondent, who has 54 minutes, and the fourth respondent, who has 54 minutes. When it comes to the petition, we've also divided the 7.5 hours. And the petition number 3 gets 54 minutes. The petitioner in petition number 4 gets 54 minutes. And the petitioner in petition number 5, who we think raises more issues, gets 2 hours, 6 minutes. So that's the formula we have come up with, but we are open to suggestions. Perhaps as you're drinking your wine this evening and discussing issues, you can redo and represent a formula to us tomorrow. The only thing we cannot do is that we cannot change the entire time, which is 15 hours.
And just to cap it up, just to assure Mr. Ben Nasser that the court is not sending any signal whatsoever. It was just a time proposal, because we have 15 hours. Yeah.
So, to the contrary, I think the signal was being sent to us, because as far as we are concerned, there's no equality of arms here. we are one petitioner against all these respondents. So there must be equal time between the petitioner and the respondent, and the formula used has given almost double time of what has been given to the respondents. In fact, without opportunity for the petitioner to now reply to whatever the respondents state. So I would suggest that any formula which is adopted must have equality of arms. And the equality of arms is each party before a court is entitled to equal time. No party can be given more time merely because they have multiplicity of numbers. If in the event, the position is that the second respondent is only joined because he's a returning officer, and therefore an agent of the first respondent. The third respondent and the fourth respondent are only joined because they have an interest on the issue. There are no allegations against them. Yet, when you take the total time given to them against the time given to the petitioner is left with almost a quarter of the time. And really, doesn't suggest fairness, suggests that the petitioner has to be on the run to prove his case. He has all these allegations which he has to prove, and there will be 5 answers against the same allegations. So I would suggest that we think of a much more fairer distribution which creates an equality of arms between the petitioner and the respondents.
So I suggest that you think through the formula, and we can conclude it tomorrow. Yeah, that's fine. We've given you a formula. We have heard you have other formulas. So let's conclude it tomorrow. If it's dividing equally and you agree that is the case, that's fine with us. Okay? Can we meet tomorrow?
All right.
Very well, coming to the end of the first day of the pre-trial conference here at the Supreme Court. Quite a number of substantive issues raised throughout the day and the better part of the evening. And of course, the final thing being the contest over the allocation of time between the respondents and the petitioners in this matter. And of course, the earlier ruling that was made by the Supreme Court judges on the question of retelling votes in 22 polling stations across the country to ascertain whether the presidential poll tally was equal to the number of registered voters in those respective polling stations. And of course, that retelling will be done tomorrow. And the results of the retelling exercise will be delivered at the court, or in court rather, on the 27th, that is the day after tomorrow. And so, as it were, other than dealing with the substantive issues of the day, the Supreme Court has also been able to make a critical ruling on that touches basically on the petitions that have been filed here and the presidential election results. And also the whole question of scrutinizing Form 34As that were used in 33,000 polling stations across the country, and also Form 36 that were used in 290 constituencies. Form 34A, for the benefit of our viewers, are the forms where the results of the presidential